Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your muted host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. I'm so pissed. Okay. Here we are. That's why you're early. You gotta be early if you're gonna be muted. Okay? You gotta be early. Where is my... Oh my gosh. Sorry, just a second. Do I need to do this? Do I need to? No, I don't. We're fine. Okay. Oh, how's it going, guys? Happy Black Friday. The true November holiday. Thanksgiving doesn't matter. All of that is canceled. You know what we will not cancel, though? Deep discounts on products nobody wants. And oh my goodness, I was laying down, laying in my bed. Now my hair's everywhere. So we'll make it immaculate for Angry Baneling. Oh my goodness. It's deep discounts on products nobody wants. We can't stop that. We cannot shut down retail's yearly lifeline. That we have to keep that open. But trust us, COVID's really real, though. You can't get it at a retail store, we've learned, or before 10 p.m. But definitely don't go to a bar or restaurant or anything else. But you have to line up dick to ass with everybody to try and get a PS5. But don't worry. Don't worry, you're not going to get COVID in the line to GameStop. You're only going to get COVID at a restaurant, bar, or with your family. That's where you get it. That's where you get it. Oh my goodness. All right, guys. So, today is Black Friday. That is Black Pill Friday, courtesy of my man, Q. Make sure you check out his channel, Out of the Darkness, on YouTube. Anyway, he helped me, he helped me realize that we could do a Black Pill Friday stream. All your Black Pills, at deep discount prices. So that's what we've got. Oh, goodness. Anyway, so I have some various things to cover tonight. Multiple things. We've got interesting lawsuit developments in Pennsylvania, including one that didn't exist when I made the link. As in, we've got fresh off the printing press news from Pennsylvania. And let me tell you, this news is a white pill. This news is a white pill. Yokozuna says to do a Black Friday sale, I read $10 super chats as they are sent. Oh my goodness. Oh my goodness. Yokozuna, you are a marketing genius, but I will one-up you. I will one-up you. How about we do $5 super chats as they're sent? There you go. It's a $5 discount super chat stream, I guess, for Black Friday, in honor of Black Friday. So we can do that. We'll do that. Mods, if you could periodically, as the show goes up, I guess, let people know of that. Okay, so we do have some black pilling to do, although I am going to make an effort to not be the one to black pill you. I am not going to do it. I'm going to let other people black pill you. Because you don't believe me. And you keep yelling at me and fighting with me, I'm going to let other people do it. Other people. I think that'll help. So we're going to have other people black pill you And I will deliver the white pills. I will deliver the white pills. since I'm going to be pissing everybody off. All right? And yes, I have a feeling we'll be reading a lot of chats, and they're going to start in just a second, okay? We're going to go back to the old days with this. We're going to go back to the old days of reading the chats as they come in. Here we go. Here we go. Trust the plan. Trust the plan. Trust the plan. Bad Vibe says, okay, if an OnlyFans thought goes to the gynecologist, who has to pay? I don't know. That's hilarious. Stiga says, if the Dragon's Treasure makes $2,000 gross profit before next Friday when Drexel's MGTOW show premieres, I will buy and send a Bad Dragon dildo to Drex. What? Guys, you saw the challenge. And Dragon's Treasure says, I don't condone or condemn the purchase of my brethren's fake genitalia, but I'll take your money. Use coupon code NICK to get 10% off and make Drex a happy and loose man. Okay. Deli 8079 says, so Blackpilled he muted himself for our safety. Yes, that's true. Brian and Taryn says, Angry Baneling hates redheads, confirmed. Wow. Angry Baneling. That's very racist of you. Corey Goodman says, no way. It's a doorbuster. It's Bonanza. It's a Bonanza. Biden the Cold One says, Angry Baneling searches for rupees in his own excrement. Yoko Huna says, in honor of Black Friday, can you do your impression of your black friend? Nick, do you love black people? You love black people? I love how Destiny couldn't answer that question. The answer, Destiny, is yes, of course. Of course you love black people, you weirdo. Andrew War Snowboard says, Rainbow the Brute this Sunday. Hype. Wait, Rainbow Brute's coming out this Sunday? RZEQDW says, can you say, behold, the most powerful spell of all in Kermit voice? Check Discord DMs if you want to know why. I'll have to check later, maybe. Austin Heartless says, $5 super chats. Oh, damn it. $5 super chats. I'll take 4. Did I do it right? Yes, you actually did it the most correct. What is this? What is this DM? All right. All right, I'll show it. I'll show it, okay? Here we go. This is for RZEQDW. Behold, the most powerful spell of all. Eat some lead, bitches. There you go. All right. Okay. Moving on. Luthien. No, wait. That's under. Phantom RA Cass says, what you say, Doomer. Well, here it comes. The Captain Z says, trying to enjoy some Scottish whiskey. How do I it? I'm a beer drinker trying to expand my drink. Also, you make me want to commit a crime so I can have you as a lawyer. Not recommended. I will. The Captain Z. Scottish whiskey, you say? I have any scotch? I have any scotch? I do. I have a little bit of scotch. A little touch of scotch. You wish Kermit would put you out of your misery? I am also Dr. Kermit Borkian, and I can help you peacefully sunset into that good night. Pay up, cash only, please. All right. Captain Z, this one's for you. This one's for you, buddy. Take your scotch. This is Lafroig. Quarter cask Lafroig, all right? You take your scotch. You put it in your glass. Swirl it around a bit. Let it open up. Then you take a big whiff of it. This smells like acidic fire. A little bit of rubber. Then you're going to I'll tell you the next step. You're going to take a small sip, but a good amount, and then let it sit in your mouth on top of your tongue. Let it hang out there. Let it fall down from your tongue to the lower part of your mouth. Let it marinate in your mouth a bit. Then after that, you're going to, after just a moment or two, you're going to swallow with purpose, and then you're going to breathe out. That's it. Very simple. Nice and slow. 1, 2, 3, 4. So sniff. There you go. That's how you enjoy scotch. Trust me. If you think scotch is too harsh, if you can't take it, if you don't like it, try it that way at first, and then you'll be an alcoholic in no time. It'll be perfect. RW Bimby says, $5 sale. Woo, capitalism. Automata says, so you see that propaganda shared by Jay Inslee on Twitter? Don't host gatherings even in your own home. I did not. Franco Miranda says, what up, Nick? Today marks my 30th birthday. To quote Andy Worski, happy birthday, buddy. I won't be able to tune in tonight, but I want to thank you for your continuing coverage of the Vic case in addition to helping him. Here's to appeals and hope you're well. I am very much, and we are waiting on that appeals news. Lara says, all these pills are upsetting my tummy. Realistically, it's not going to be as good as bad as we think, right? Well, depends on your imagination, I suppose. Brian and Terrence says, Timmer is a good Christian boy. Funny Valentine 2020 says, Nick, worst anime you've ever watched, finished. I think it's Blood Sea was really kind of bad. I mean, it was entertaining though. I hated Tokyo Godfathers. There's got to be a one-off somewhere. I don't know. I don't know what it would be though. I really hated Tokyo Godfathers. I did. I know other people like it, but I'm not commenting on the quality of the show. It's just not my type of show. It's just not. I hated it. Gadam Lou says, here's your black pill on the importance of escapism. All my forms of escapism, both physical and digital, are being attacked and destroyed by Reds and Democrats. They want to destroy everything I have loved. They do. They absolutely do. You're 100% right. And the only solace that you have is most escapism is preserved in archival sort of copies, like 2nd edition D&D or 3rd edition, that type of stuff. Yokohuna says, just like in real life, you cannot use a coupon with a sale, so Kermit voices are exempt by technicality. Shift the grift, no Kermit. Pirate Chan says, Nick, Star Trek isn't communism. Federation is the unofficial military. It's just a post-scarcity society. They still have private property and money. I thought they got rid of money by the 24th century. The Captain Z says, Glenn Morgaine, 14 years age. You mean Morangi? Is what I have. Yum. I don't know. You might have Morgaine. I don't know. I'm not saying that's not it. Angry Baneling says, Nick, help. My position, the high priest of the Church of Ginger Worship, is at risk. They're trying to depose me. How dare you, chat? Brian and Terrence says, Angry Baneling caused a potato famine because he hates gingers. Goodness gracious. Biden the cold one says, Angry Baneling says he much prefers his gods, the cows, over both rupees and redheads. He is disgraceful. Good Lord. Malik Foxon says, you will get nothing done this stream now. That's true. Joseph Kerwin says, I'm reporting you to my governor. There's no social distancing in the chat, and I observed several people drinking after 8 p.m. Oh, my. Oh, my. Biden the cold one says, angry. Oh, wait, I read that one. Arctic Pharaoh says, say PPP1, Ron beats judges kids. Vic said something sexual in my ear. Maxwell is still alive. Epstein still didn't kill himself. Woke is good. Woke is good. Woke is hood. In Kermit, take my money, Nikki. Damn it, Arctic Pharaoh. PPP1, Ron beats judges kids. Vic said something sexual in my ears. Maxwell is still alive. Epstein still didn't kill himself. Woke is good. Woke is good. Woke is hood. Okay. Understatement says, are we going to hear the story of how Republicans may have actually found their stones today? No. Not yet. Partly. Maybe. Captain Z says, trying it now. Looking AAA meeting also well. Multitasking for the win. Phoenix Lord Azerman says, Josh is trying to contact you relating to Greer. Please answer him. I don't want to see you in the cornfield like the Gunt. Okay. I will do that. I think... Oh, yep. I was supposed to reply to him today, and I did not. I'll do it after the show. Versi says, Neon Genesis Evangelion. Worst anime ever. Worst anime ever. Andrew War Snowboard says, Maxwell is still alive. How come he stopped making YouTube videos? If it's Kimball you're talking about, I think he got flagged down by the mundane Matt. Big Red Bear says, in Kermit's voice, Star Trek's post-scarcity democratic socialist society, not communism. Communism doesn't have a hierarchy and is basically an anarchist state where everyone magically cooperates. Also, Trump still lost. Okay, there we go. Let's get into this. Let's get into this. I need to pull up a clip. Since you guys don't believe me, I don't know if we're going to go through all of this clip, but we're going to go through some of it. It is a former guest of the show, a friendly,
the Trump campaign has
beanied individual that many people find to be absolutely lovable, and that is Mr. Tim Pool. Mr. Tim Pool. I am going to do this to you because you have forced my hand. And like a vengeful parent, I must now, it is my duty to do this to you. So we are going to listen to Tim Pool for a couple minutes, okay? His video is 11 minutes long. I don't know if we're going to get that far. But we need to do this. We need to pull Tim Pool here. Because again, you guys don't want to listen to me, okay? So this is your fault.
The Trump campaign has vowed to appeal their lawsuit to the Supreme Court. Now, this video will be kind of an add-on to my earlier segment over at my other channel, which is the Tim Pool YouTube channel, which you can find at youtube.com/Timcast. Type that in, and you'll get a different channel. And
Oh, by the way, I maybe should have prefaced with this. Rudy Giuliani's appeal to the appeals court. Remember, Rudy lost. That was the case we covered earlier in the week. We listened to the oral arguments of Rudy Giuliani, and we listened to the counter arguments, and they lost that case, and then they appealed it to the appeals court. And I pointed out that that appeal was going to be limited in scope to the very narrow issues that are preserved on appeal. And in this case, the only issue they brought to the appeals court was, did the trial court abuse its discretion in preventing them from having a second amended complaint? Now, I received much yelling and negative comments from the chat, which is fine, but I'm just, it's okay. I'm just labeling them, saying how I was dumb because Rudy Giuliani's plan was to lose in the Supreme Court, or lose and get to the Supreme Court. To which I respond and still maintain that is a stupid plan. It's a bad plan. It's also not his plan. But I even took under consideration the possibility, okay, even if it is his plan, though, I said it's executed in the worst way possible because they didn't preserve those issues on appeal. This was with uncivil law. We talked about this. Okay. They lost that appeal, and it was 3-0. Now, real quick, all of those judges, before anybody comes, whether they hate Trump or whatever, all three of those judges are Republican-appointed judges, and the justice who wrote the opinion, the chief judge of that circuit of appeals court, is a Trump-appointed judge. So, before we just want to head that off, it's not an Obama appointee or anything like that. It was a Trump-appointed judge who said that the campaign didn't bring shit, period. And that the ruling of the lower court was correct. They didn't abuse their discretion. No injunction. Guys, that case is a stinker. It was a stinker. It was definitely a stinker when they amended out all of the fraud accusations. And then Rudy said in open court that it wasn't fraud. I don't know what to tell you. It was a bad one. That isn't the end of the road in anywhere else, but that case is terrible. It just was. Nothing else I could say. But they lost that appeal case, And I'm not going to talk much about that. I'm going to let Tim Pool do it, because if you listen to what Tim Pool says, you'll hear some familiar stuff if you've been watching, okay?
Talked about Donald Trump losing his appeal to the Third Circuit. Now, the Trump campaign has vowed to go to the Supreme Court. But one lawyer, Will Chamberlain, who is a pretty avid...
Two lawyers, Will Chamberlain and me. Nanya Biz says Rudy never should have had Ty prep the briefings.
The Trump supporter says he doesn't think they're going to win. Now, that's important, but I don't think this lawsuit is actually Trump's real legal strategy.
Oh, here we go.
I'm not convinced, and I haven't been for a while, and I said it like a week and a half ago on the IRL podcast. I'm not convinced the lawsuits are anything but Trump buying time. Now, of course, if you're...
I mildly disagree with Tim here, but we're tracking the same on what I've been saying for a little while.
On the left, you can say cope, and Tim's trying to justify why Trump might win or whatever. It's like, dude, I'm not saying it's a good thing, and I'm not saying it's gonna guarantee anything for Trump, and I'm not saying that Trump is a good person for trying this. I think Trump is trying to buy time to justify an electoral the Republicans in these swing states flipping the electoral votes to Trump, and it looks like it's working.
I think it was yesterday. Maybe the day before, but it was either yesterday or the day before. I was talking about this two-pronged strategy. And this isn't the first time I've talked about it. You've got your legal attack and you've got your media blitz. And the media blitz, the purpose of that is to convince Republican base and then by extension Republican representatives to attempt to undo the electoral votes of their states. This I have classified as the hailest of Marys, the longest of long shots, and it is. But it is also the double track. Now, where I disagree with Tim, oh my God, that's an unfortunate pause I gave him. Where I disagree with Tim, I don't think these lawsuits are intended to buy time for that. They're a dual purpose thing. They don't have to be either or. They're both and. But as they lose them, they're trying to get attention, energy, and support for this other strategy. You know, if they were winning the lawsuits, believe me, their strategy would just be the lawsuits and they wouldn't have this public media strategy. When you start losing the lawsuits, you switch to the PR strategy, and that's fine. By the way, this is something that has existed long time before the Trump campaign tried it in law. This is a very valid legal strategy for any public matter. Johnny Depp is trying a similar thing. You know, blast your opponent as hard as you can, make them look terrible, try to get the public on your side even if you can't win in court. Because court is messy and fickle. But if you can win in public, you can still win in practice.
Doesn't mean Trump's going to win, but as per my main segment on my other channel, Republicans in Pennsylvania want to file a joint resolution to take back the power to appoint electors. The only reason this is happening is...
This is also happening in Wisconsin, where they've actually filed a challenge to the electors. Republicans in Wisconsin have filed a challenge to the electors to try and stop the certification. It's like the step before actually just doing it at the legislative level. They're trying to do it through the judicial process still, but they're trying this in Wisconsin. Republicans are. It's kind of interesting to see. And Nevada as well. Like Nevada, well, Nevada's a whole different case, but Nevada is going actually better than I originally expected. Although I hadn't read that document, reading through it today, I can see why they are doing a little bit better than other places in court, but we won't know about Nevada until I think December 2nd or 3rd. So anyway.
Is because Trump is making these claims and asserting fraud. And that's why I don't think these lawsuits matter all that much. Trump is buying time, otherwise he'd look ridiculous. But here's the news from the New York Post. They say, a federal appeals court on Friday upheld the results of Pennsylvania's presidential election, leading President Trump's campaign to vow a final challenge before the U.S. Supreme Court. A 3-judge panel with the 3rd U.S. Circuit Court of Appeals in Philadelphia unanimously rejected Trump's bid to overturn a lower court ruling, saying, that his campaign's claims have no merit, the AP reported. Quote, free, fair election.
I'm not going to sit through this part. I'm going to go ahead to where he goes to Will Chamberlain's analysis here, okay? Because what he basically does, he goes through the article, New York Post. Long story short, that lawsuit is shit. Everybody who looks at it knows it's shit. It might not have been shit if they would have kept some fraud allegations in there and brought evidence. By the way, the evidence that they brought to the Senate hearing, if they would have put that stuff in the lawsuit along with allegations about what happened, they might have gotten farther. They might have. They might not have, but they might have done better. They didn't put that stuff in there. They should have, but they didn't. So, you know, I'm telling you, I can't stress enough that whoever did the First Amendment complaint literally screwed the entire case. They killed it. There's no ifs, ands, or buts. And the Second Amendment complaint wasn't really much better. They've gone through it at the appeals court. They said the Second Amendment complaint, the reason they're denying, they're shooting it down again is because they said the Second Amendment complaint still didn't remedy the overwhelming problems with it. One of the problems being for their equal protection claim, they don't actually argue or accuse the state of treating them unequally, which is kind of an issue for equal protection. And that's in the amended complaint. They don't. So, like I said, for whatever reason, somebody biffed that case. It doesn't mean that they never had one. It means they didn't bring one. All right. So, but let's get to the Will Chamberlain legal analysis again. I just want to point out some similarities.
Now, here's the point. I have this Twitter thread from Will Chamberlain. Will Chamberlain is, in fact, a lawyer. So I believe he knows what he's talking about. Not only that, Will runs humanevents.com, and he is an avid and staunch Trump supporter and defender. And I tell you, for a long time, one of the best. I say for a long time because he's recently been saying that he thinks Trump is going to lose. And what I mean by this is I do not believe Will blindly defend Trump. I believe that he's going to tell you the truth the way he sees it, even though he really does support the man. So I'm not saying I'm not trying to disrespect Will in any way. In fact, he's a friend of mine. I think what he's saying is, look, my honest legal opinion, I don't think Trump is getting anywhere with the Supreme Court. And that's coming from a Trump supporter. Too many.
And Will's going to say this. I have to add commentary because fair use stuff. I don't want to take Tim's stuff here. We're only showing the parts that are relevant to this discussion, and I'm adding commentary where it goes. But the reason it's not going to go to that, it doesn't have much chance at the Supreme Court, is because, again, it's only the issue. This is the only argument they get to make at the Supreme Court is, did the lower court err in throwing out or in preventing them from filing a second amended petition? That's it. That's it. That's the only issue. They don't get to go to the Supreme Court and be like, look at all the fraud, because they didn't put it in their other stuff. The Captain Z says the whiskey is Glen Morangi, 14-year age. And yes, it is. Thank you. You've made a new whiskey drinker. Looking to drink whiskey to celebrate having baby number 2, and it will be the firstborn son. Good times. Plague baby for the win. Hey, man, congrats. Congrats. All babies, even plague babies, are good. Papa Nurgle is best Nurgle. Jillian Seed says Trump team has established objections to 160K absentee ballots in Milwaukee. Could that county that could be used in a lawsuit could swing Wisconsin to Trump? Check email. Yeah, and my comments about the lawsuit are literally just restricted to this particular case in Pennsylvania. They don't apply to other legal challenges that are out there. So, but they are running out of time. But again, I'm not delivering the black pill.
People, I believe, just want to be whispered. They want to hear the sweet nothings whispered into their ears. And you got to recognize it may be bad news for Trump. But like I said in the beginning, I don't think this lawsuit is part of the plan. In PA, they're going to flip.
The lawsuit was definitely part of the plan. It was just a botched part of the plan, Tim. It's okay. It's okay for them to make a mistake. Like, it's okay for them to screw up and lose from time to time. It doesn't mean, like, they don't have a pristine, perfect path laid out with all losses and wins planned. It's not how it works.
They're trying to flip the electors, and it doesn't matter if this lawsuit happens or not. But let's read. Will says the Third Circuit just ruled on the Trump campaign challenge in Pennsylvania, a 3-0 loss, opinion from 3 Republican appointed judges and written by the lone Trump appointed judge that has the campaign losing on basically every important point. The campaign tried to appeal on the narrowest grounds possible, whether the district court should have let them amend their complaint a second time. Leave to amend should be granted liberally, but the Third Circuit wasn't persuaded. Reason 1 why the campaign lost: undue delay. The campaign had stressed the need to resolve the litigation by the 23rd because that was the certification deadline. Bibas writes that it can't turn around and demand time to fix its complaint now at this late a date. That's actually an interesting point. Why would so Trump said, and this is an indication that Trump is just losing. Trump's original lawsuit said we must get this done quickly before the 23rd. After the 23rd passed, Trump doesn't want to give up, so he keeps filing, and the judge says, I thought you said it had to be done.
Tim's a little bit off on this point. They weren't filing after the 23rd. They were just filing so close to the 23rd as to prevent a reasonable court from being able to get a decision by the 23rd. So he's mildly off here, but that's okay. It's okay.
Before the 23rd. Well, now we want to amend. So I think it's fair they do because they want to decertify. But that's one point made by the court. Reason 2 why the campaign lost: amending the complaint would have been futile. Basically, Bibas writes that it was simply impossible for the campaign to prevail, that nothing they alleged would have even stated a claim for relief. Will says, back to the analysis, Bibas states that even if the campaign's proposed amendments were added to the complaint, it still wouldn't meet the Twombly-Iqbal standard of state.
Hey, we talk about Iqbal Twombly all the time on this channel. Because it's like your first day of civil procedure in law school. Iqbal Twombly states that your complaint has to have a cognizable claim on which relief can be granted. You have to do that, and that conclusory statements, legal conclusions of law, are to be ignored unless they are merely supporting existing factual assertions. And the factual assertions don't even have to be right. Like, you can be wrong on a factual assertion, but they have to be made. And this is the fatal problem with Giuliani's suit. It's not that they didn't bring evidence. It's that not only did they not bring evidence, they didn't even allege facts that would lead to a claim that the court could grant remedy of, even in the Second Amendment complaint. Biden the Cold One says, as Kermit, my name is Nick Ricada, and I always remember to shill my other channel without having to be reminded via super chat. I mean, I guess. You can check out my other channel, Ricada Media, in the description. Hoping to get some content up there over the weekend. I just got swamped this week with Thanksgiving and with all this doom pilling. So check over there for stuff that isn't legally related. Thornock Gaming says, today is my 38th birthday. Thank you for the hard work you do, Nick. Hey, you're welcome, buddy. Happy birthday.
Stating a claim relief that is plausible on its face. I'm not a lawyer, so I can't really opine further on that. He says, Bibas notes the campaign has litigated and lost most of their arguments at the state level.
That was another point in the, I have read the opinion from the appeals court. I'm probably not going to read through it on the show because I want to talk about the good stuff, not the bad stuff today, which we're going to get to. I just got to front load it with bad stuff so that you think you're getting doom pilled and then fist you awake with white pills. But the long and short of what happened is they pointed out, rightly so, that they brought many of the state court claims in state court. They lost those claims and they didn't appeal them. Instead, they tried to ham-fist them into federal court. It's not that they appealed them at the state level and lost. It's that they didn't appeal them. And forfeiting a claim by not appealing is different than losing. Had they appealed those claims to the state Supreme Court, then they could have possibly appealed that decision up to the U.S. Supreme Court. They didn't do it. They've lost on these claims, and they forfeited their rights to appeal. Again, missteps abound in the Pennsylvania case, and that may be the result of having several different legal teams on this case over the course of time.
The third big problem, the complaint tries to make an equal protection claim, but never alleges that the Trump campaign was treated differently from the Biden campaign, only that different counties handled things differently. Bibas explains that's not enough. And finally,
Zinni the Flu, real quick, you said he wants Supreme Court ASAP. Let me point out, if he wanted Supreme Court ASAP, they could have already been at the Supreme Court. This is not the ASAP. I know, I get it. I've seen the memes. I hear you. They could have already gone to the Michigan, to the Pennsylvania State Supreme Court, lost, and appealed that for cert to the Supreme Court. They could have done that. They didn't do that. Instead, they went this route. They could have already been there. I know it's really easy to read the internet memes about what they want and what they do. They're different than what they're arguing in court. They're different than even what they're saying. People are only hearing what they want to hear, and I'm sorry for that, but they are. Brian Taran says, Angry Baneling has soon me his love for the Church of the Ginger by surviving this trial by fire. Oh, shown you, I guess, is what you mean. Oh, I'm glad. Wait, did you burn Angry Baneling? That'd be good. Timothy Farley says, breaking news, check the Gateway Pundit. Top right about Pennsylvania news. I already know. Those are the white pills I'm going to give you. The other case, the one I talked about earlier this week, I have the short video on it, and then the Kraken came out and fucking ruined everything because I don't think she's even filed the Kraken lawsuit yet, guys. Sidney Powell pisses me off right now because I'm pretty sure that's not even filed. It's not on Pacer. It's in Georgia or Michigan. It's possible that she maybe filed it after closing time or something and Pacer just isn't updated yet, but she hasn't even filed it, I'm pretty sure. So we spent 2 days reading that damn lawsuit instead of talking about the much more interesting lawsuit in Pennsylvania that's actually winning, and that is the white pill we're going to get to tonight. So we're doing it. But thank you.
Bibas notes the relief proposed, stopping certification, is unprecedented, especially given that the campaign explicitly disclaimed allegations of fraud. And that is the most important point. And that's actually a point that I made, not being a lawyer. These judges don't want to make these big moves. Even if you said, here's a picture of a guy committing massive fraud, a judge is going to be like, but I can't do it. It's unheard of. It's such a major move to block 7 million votes. I refuse.
Minor disagreement with Tim here. I mean, he's basically right, but he said, even if you had a picture of a guy doing massive fraud, the problem is they don't have that. And if they did have that, a judge might actually be willing to do it. But we won't know because they haven't presented that yet. All right. So, but I've been saying this over and over. You're going to be hard pressed to find a judge. And remember, these judges live in that state. So you've got 6.8 million Pennsylvania voters. If you throw out all of their votes, someone will kill you. They just will. They burned down several cities over some guy none of them have ever met getting killed. You throw out 7 million votes, 1 in 7 million chance you get offed.
Even though they might have the evidence or good reason, there is still a hurdle to get over of, but your relief requested is disenfranchising 6.8 million people.
Bullet pill.
And that, even if you can prove substantive fraud, how do you disenfranchise all the others? The problem then becomes there's no right answer. Disenfranchise the entire state probably is the right answer, but think about how many millions of people who legitimately voted get discounted. But if the election isn't, if Joe Biden's ahead by 81,000 votes and 100,000 are bunk, then Trump would win, in which case the fraud itself is disenfranchising all of the Trump voters. You see the problem here? So the only...
And minor disagreement with Tim, again, the fraud isn't disenfranchising the Trump voters, it's every voter. The fraud disenfranchises every voter. And it does. And that is how you overcome the judge saying, I don't want to throw out all of these votes, is by showing clearly specific allegations of fraud, which they haven't made in Pennsylvania effectively or really at all in court. You got to show the fraud and bring the evidence, or you got to allege the fraud specifically and bring the evidence. The other problem is the only claim that they had about the equal protection claim, right? Where some people were given a notice to cure and others weren't. The total amount of votes that it's finally been revealed, I guess. The total amount of votes in that equal protection claim was 6,500. So even if they went through and removed all of those votes that they said were the basis for their equal protection claim, you're still losing by 7,400 or 74,000 votes. These are the fatal problems with the Pennsylvania case. Again, it was ill-conceived. They really needed more than what they had at the time. I know Rudy sat in front of the Senate hearing, and the colonel sat there and talks about 600,000 votes. That basically, the allegation in summary is that 1.5 million absentee ballots were sent out because 1.5 million were requested and like 2 million something came back. So they've got this big block of votes that they can't figure out where they came from. That's really important. That's something that should be discovered and investigated and talked about. Not in the case. Don't know why. Don't know why it's not in the case, but not in the case. So those types of things were not in there. Now, they've been at least presented to the Pennsylvania legislature, and they're being used in an attempt to get the Republicans there to change the vote. And they have the power to do it. They can do it. Will they? It's a really tough call. A really tough call.
The only thing they can do, I guess, what the electors are likely to do, in my opinion, no electors appointed for anybody. All right, nobody gets anybody. Will says in conclusion, this is an opinion that basically ends the litigation. The campaign can go to the Supreme Court, but it's like 99% chance that they will simply deny cert and not hear the case after an opinion like this. Why? Because the opinion has the campaign losing on so many alternative grounds. The Supreme Court would need to be persuaded that the Third Circuit was wrong on both both timeliness and on the merits of the underlying claims. Don't see that happening. Bibas's analysis looks right to me. People seem to think I'm happy about this outcome. I'm not. I would love to be wrong, but I'm also a lawyer, and I'm not here to BS you.
All right, I'm not going to listen to the rest of Tim's stuff. I wanted you to get the Blackpills from Tim and Will Chamberlain because, again, everybody seems to think that I'm a crazy idiot, which is fine, but just because I'm a crazy idiot doesn't mean that that I'm incorrect on this stuff. Importantly, I'm not giving you my answers. I'm just telling you what judges are saying about the stuff. That's so, clearly there's a difference of opinion because you've got lawyers on Trump's side saying one thing. You've got lawyers on the other side saying another thing. And you've got judges saying something between them, usually heavily weighted towards one side or the other. But that's how court goes in reality when it's not on TV. Midnight in Exile says people who think they're going to F around are really going to find out when there's no election to motivate holding return fire. Wonky says got a bonus at work, went to the local liquor store and got Whistle Pig 10, 12, and 15 years. Ooh, also got Glenlivet 12, 14, and 15 years. Take a drink with me. Dang. Yeah. I'll go with this peg leg porker. The solid selection you got there, Wonky. SY 1990, there was a tiny drop left, and I wanted to drink that drop before I poured in a different whiskey. This is the glass I just poured. Peg leg porker. Delicious. All right. Why is Greta Thunberg in a robot suit on the wall? All right. So there's that. Oh, and I do have one more video clip for you. This one's shorter. And it has a completely different black pillar. In case, again, you don't believe me, which is fine. You're allowed to not believe me.
Rudy.
Are you ready? Are you ready? And then after this, we're going to white pills. We're race swapping into white pills.
He's the greatest mayor in the history of New York, and there's a reason. He's got great courage, and he doesn't care. He wants to do what's right. This is going to be your crowning achievement because you're saving our country.
Rudy Giullani.
Okay. Wonky said, also thought you couldn't find Whistle Pig anywhere. Just across the river from you in Wisconsin, and we got it here. No, Whistle Pig you can find. If there's someone said you can't find the Whistle Pig Boss Hog anywhere. I don't know about that. I know that my liquor store stopped having it. I bought the second bottle, which I'm bringing to Tampa. Road Rage, by the way, if anybody's going to be there. I bought the second bottle of Whistle Pig from the store, and they haven't gotten a third bottle. The Whistle Pig Boss Hog. The one you can't get around here is this peg leg porker. You got to get it in Tennessee. So, Von Cobra says, how many black pills did I miss? What will be lost? Summary version. Well, you've missed some, but don't worry. They're cheap, on sale today. Black pills are deep, deep discounts, and you're going to get one from someone else today. Not this plastic-looking man, but the next man. Bad Vibe says, at Twitter support, would you mind changing your disclaimers to reflect the situation? There are legal challenges to the current election. Stay tuned for updates. Certified results will be reported December 14th. Nice. Well done. They have the Boss Hog at all your liquor stores down there. $6.99. My last bottle, I paid $4.30 for the last one. So damn. Okay, here we go.
Giullani on Friday getting a shout out from the President of the United States, and he joins us right now once again. Great job, Mr. Mayor. Great to see you. Welcome back to Newsmax. How are you?
Thank you, Greg. Very nice to be back with you.
First off, the appellate ruling in Pennsylvania did not go your way, but I guess you kind of want it to not go your way because you want to get this thing to the Supreme Court right away?
Sure. I mean, what we wanted out of that case was a hearing so we could put.
So notice how he says, sure, yeah, but that's no. What they wanted out of that case was a hearing, which is not true either, by the way. What they wanted out of that case was a win, because you bring a case in court to win. Then when they couldn't get the win, they wanted the hearing. They didn't get the hearing. Now they did get the hearing, just not in court, which is fine. But listen to his attitude towards the Supreme Court case.
Put our witnesses on. The judge wouldn't give us a hearing. The appellate court wouldn't give us a hearing. But we got our.
The appellate court isn't going to give you an evidentiary hearing. That's not the role of the appellate court. You don't have that. Your hearing would have to be in the district court.
Hearing with the state legislature. So, in essence, we accomplished the purpose of that case in the Supreme.
Look at it. God, he looks like Robert De Niro at the end of Casino.
Court can now take a look at. But we wanted to get, finally, after all the censorship that's going on, we wanted to be able to show that we have evidence, and we have a lot of it. So we put 10 or 12 witnesses on who observed the fraud. They observed the counting of ballots multiple times, the same ballot being entered in a machine multiple times. They observed the complete isolation of the Republican inspectors for well over 600,000 ballots. And the only reason that was done is so that they could cheat. They didn't want to be observed cheating. We had witnesses that said that in one part of the state, if you made a mistake
Corey
on
Goodman
the
says,
ballot,
hit
you could
like
fix
you
it.
figs.
Other part of the state, the Republican part, you couldn't. Well, fixing it means committing forgery. When you fix a ballot after it's been submitted, there's kind of like forgery involved.
There isn't forgery involved if you allow the person who cast the faulty ballot to cure it. I got to correct Rudy here. Notice and cure procedures being legal or not is separate question. Just because someone is fixing the ballot, that is not necessarily forgery. If you're talking about notice and cure, like someone curing their ballot, their first ballot is invalid, so it's not cast. So then curing it can't be forgery. If you're talking about the thing where they actually fix a ballot with a Republican and a Democrat sitting across the table from each other, that has happened in several elections prior to this, and I guess it could be possible that that there's fraud happening or forgery happening, but they haven't alleged that any of those ballots were forged.
And then you have this very strange situation where there are more ballots that were counted than were sent out by a couple.
That's a very strange situation. It is the one of the most important claims. I'm not sure why we're just hearing about it at the hearing and why it wasn't in the lawsuits.
100,000. How did that happen?
Well, Mr. Mayor,
Bart Silverstein says, which boss hog, Samurai Scientist or Magellan's Atlantic? Samurai Scientist is the one I'm talking about.
wait a second. You just said you have evidence. Mr. Mayor, you just said you have evidence, and I have been hearing from the mainstream media from the get-go that there is no evidence, and it's all unverified. And you made that point in the press conference last week. You've got affidavits. You got hundreds of them. You unveiled some of the evidence at that hearing, and they continually say you have no evidence, and all of this is unsubstantiated.
Even after the hearing with the witness, three of them very, very distinguished careers in the military. One of them is a cyber expert who actually can testify.
Which means he played a lot of WoW and thought everybody was actually a girl.
To how information was being taken out of the machines. People, lawyers, doctors, I mean, people, very substantial people and very regular people. They're not going to put their names on an affidavit under penalty of perjury for something like this. I mean, the numbers are astounding. They cheated with over 700,000 votes.
You know,
this
Mr. Mayor,
is a big fraud. It's not little.
No.
And it happened the same way in 6 states. So now we're going to move on to Michigan and to Arizona.
Anybody else ever notice that Rudy Giuliani's teeth are like slanted like this in his mouth? His top teeth are like, it's crazy. It creeps me out because his bottom teeth like go up like it too. I don't know how his jaw fits together.
To Wisconsin and to Nevada and to Atlanta, Georgia, where the same thing happened.
when you file a lawsuit, by the way, and sometimes in court proceedings, you can have a hunch, you can have suspicion, you can have some evidence, but you bring it to a judge, and a judge can say, oh, you've got something here. And then it goes into a phase called discovery, if I'm not mistaken. A judge can...
Yeah, we have never had that. We were deprived of that by the judge. The judge just threw us out. He threw us out. He decided the claims weren't true.
That's not what the judge did. Mithran Emmer says, Trump's legal teams are reminding me of Macbeth. They have, quote, tales told by idiots full of sound and fury but signifying nothing. Banking on SCOTUS is a fool's gambit. Bring the legit cases in state court. I agree. And we're going to, again, yes, I know about the Pennsylvania State Court appellate court ruling that just came out tonight. It came out after I even created the stream. I've read part of it. We're going to read all of it. It is the white pill, the who-white pill. It's really interesting. It's what I was talking about. It's a claim, and believe me, the people on Law Twitter really don't want this claim to exist, and it keeps moving forward. It is a fascinating claim, and we're going to talk about the claim, about the legal realities of it, and about why it keeps moving on. So very, very interesting. Nice freeze frame. Versi says, you know you're a WoW player and your microwave goes ding and you say grats. Well, maybe. I didn't ever play WoW at all, but EverQuest, the ding. Oh my gosh. It was a magical thing because it took days. Bad Vibe says, actually, I noticed Rudy is picking up some of Trump's speaking style. Royal Wind says, how long do you think MAGA will continue to believe Rudy and Powell? People need to start accepting reality. I don't buy into accepting reality because we don't know, frankly, none of us know what reality is other than after the fact. We don't know what they have. We don't know what they have planned. We don't know what's coming. And importantly, we don't know what a judge is going to do or what a legislature is going to do. So again, when I'm talking about this stuff and I'm pointing out what I think are issues with it, I'm basing that on how other judges are ruling on similar issues, either in the past or recently, as I was in Georgia. I'm not saying how the next judge is going to rule. I'm pointing out areas that are problematic and areas that, if you know about the other rulings, you think you would maybe touch up and change the arguments a bit. Mithrin Emmer says, Rudy, L. Lynn, etc. are making it about them, not about what happened in the States. Stop making TV appearances and put together good cases. The facts exist to write and file them. Stop the games. Mithrin, I will mildly disagree with you because I do fully believe that there is a two-pronged push on this, that the legal prong is part of it, that the media prong is another part of it, and that the legal prong symbiotically feeds the media prong. And that's why we're getting cases with more and more sensational claims in them, even when they may think those claims have less likelihood of succeeding. So here we go.
It just threw us out.
Again, when the media say, well, there's no evidence here, I mean, if you get a judge, and you will, like it would say, compel the other side to produce evidence. I mean, that can happen.
We'll get a judge like that, but right now we can't wait, so we're going directly to the legislatures. Look, the Constitution...
We can't wait. They did wait. That was actually part of the problem in their appeal, and that's part of the reason that they lost. And a big part of the reason is that they kept waiting rather than filing.
The United States puts the selection of the president in the hands of the state legislature, not the governor, not the attorney general, but the state legislature. They set the rules and they decide if the vote is correct. So we're going to each one of these state legislators and we're saying, if you certify that vote, you're certifying a false statement. You're committing fraud because that vote is not the right vote. Biden did not win the number of votes that he has attributed to him. Some of those votes he won by taking a ballot and putting it in a machine and counting it 5 times. So he would get 5 votes for every one that Trump got. And we've got witnesses to that in Pennsylvania, in Michigan, and in Arizona.
So that's the game plan.
They followed the same fraudulent patterns in the big cities where they control like dictators, where the Democrats have dictatorial control and plenty of corruption.
You know, it's wild. They keep accusing your side of waging a coup, and everything you're doing is totally legal, within bounds. The Electoral College has not convened. These things haven't been sent in yet, which I find ridiculous. So has your strategy shifted, though, to primarily a political one than a legal one? There's not enough time, perhaps, to get relief from the courts. So you're going right to the legislatures, all of them that you just mentioned, and basically trying to persuade them this happened. So electorally, when you guys get together, your electoral vote should not be allocated for Biden.
We're doing both with equal speed, enthusiasm, and taking advantage of which one gives us the hearing the quickest and which.
What did I say? I'm telling you, they are pushing both fronts. They have been pushing both fronts the entire time. It's why they don't care about the inconsistency between their public statements and their legal statements. Their public statements matter in public and don't matter in law. Their legal statements don't matter if most people are hearing their public statements. So that is why we have both of these things happening and why they sound different, even though they're both happening from the same people.
Which one will work fastest for us? Because we don't have a lot of time. We've got a lot of evidence. We don't have a lot of time. And when we're facing a major censorship, so that it's very hard to get this information out to the public. Public has only a small idea of the kind of evidence that we have. You know, the situation in Michigan was worse than the situation in Pennsylvania. The situation in Wisconsin was outrageous. I mean, they have all these absentee ballots without applications. In Nevada, they used a machine that basically didn't work, and it let every signature go through.
This is why the Nevada case is so damn interesting, and we might talk about it a little bit tonight, and why that case is moving forward. In Nevada, in Clark County specifically, they use a type of machine for signature verification. Now, this machine is used in several states for signature verification. What is alleged in the Nevada lawsuit is that in other states, it is used to flag potentially mismatched signatures. So, you know, they run a big stack of ballots through it. It flags ones that don't look right. And then what someone does is they go in and individually look at it, and they determine whether or not the signatures really do match, right? And there's usually a bipartisan process for that. Clark County, which is Las Vegas, got so many mail-in ballots that they weren't actually prepared for that many to come in. This is what's alleged in the suit. And so what they did was, instead of doing the flagging process, they let the machine determine entirely. And they used lower recommended settings, or lower than manufacturer recommended settings on the accuracy of signature checks than the manufacturer allows. Now, Nevada is off by how many votes? I don't know. But 130,000 ballots went through the machine in Clark County. In this particular machine, which I don't know how many they're off in Nevada, but 130,000 is more than that. And so in Nevada, they have a cognizable claim. They have laid out the basis for it. The doubt is sufficient to change the outcome of the election. They can say and they can point to procedural defects. They can point to last minute changes that were not permitted by the legislature, but made administratively and only in Clark County. They can point to objections that existed prior to the election. The Clark County complaint is well laid out. That's why it's moving on. It has all of the elements necessary to go ahead and get past the initial phase. Unfortunately, many of these other lawsuits have not. But, you know, Nevada is a state. Nevada. How about Nevada? I know you guys want me to say Nevada, okay? Nevada is a state in which a flip could potentially happen, in which the flip would be meaningful. So that is an interesting, well laid out case, and we're going to see how that goes. Again, their hearing is in December 1st or 2nd. Literally everyone says these black pills feel more like suppositories. Bad Vibe says the fun part is how much credibility the Dems and MSM have lost in the last 4 years. People see the Dems and MSM as Richard potatoes. Okay.
Even though it's illegal to use the machines. I mean, they cheated in all the places that were critical to them. And you know they did, because Trump was way ahead on the night of the election. It's impossible that Biden would have come back at every single one of those places. Impossible.
Especially places like,
it's unlikely.
You know, the 4 cities where he beat Hillary Clinton, only 4 cities did he do better than Hillary, which is pretty wild. Milwaukee, Detroit, Atlanta, and Philadelphia happen to be key cities in great big swing states run by Democrats. I think there could be something there, don't you think?
Oh, there definitely is. They picked what you would call home field advantage. Home field advantage means cities that they've been running for 30, 40, 50, 60 years, and they're crooked as heck.
All right, we don't need the rest of this. I just wanted to point out that I'm not saying crazy things, okay? I know I'm not saying crazy things when I'm telling you that if you listen there, Rudy doesn't care about the Supreme Court case. They know they're probably not going to even be heard in the Supreme Court case based on what's happened in Pennsylvania so far. He doesn't care. They got the hearing. That's what they wanted. And that is fine. If they're going to state legislatures and getting them to push for undoing the certification, do it. That's a strategy they can take. I believe Minnesota Republicans have been pushing for it they'll lose because we are the most communist state you can find, except for Virginia this year. But yeah, Wisconsin has moved for it. Nevada, or whatever you want me to say, has this lawsuit going on, and that is something interesting. But what we're gonna do now, just give me a second. Sorry, give me 1 second. Sorry, we got kids running around being crazy. Oh my goodness. Saga of Blood Ninja says, Nick, see if you can get Robert Barnes on the show to talk about the lawsuits. He regularly streams with Viva Frey and seems like he has been involved to some degree as a voluntary consultant. Sure. Happy to have Barnes on. Had him on before the election. Happy to have him on again to talk about it. Then maybe you guys can be mad at him instead of me. At this hour, WTF, X Louise 89, X. Yeah, exactly. What I said was go to bed. Go to bed. All right. Your lack of faith in the plan is disconcerting. I'm not going to argue anymore. We're going to switch to white pill mode. Okay? Here we go. Is this it? Oh, I got to pull up the newest document. I was looking at it on my phone. I'm getting it. 1 second. All right, we're going to look here. Kelly versus Commonwealth. All right. Now for your dose of white pilling. Here it comes. Open your mouth. Relax your throat. This big white pill is coming straight for that esophagus. Automata says, so a lot of folks have been saying you don't tip off people by showing evidence in advance. What exactly is the disadvantage of leading earlier with the idea of 100,000 more ballots counted than sent? Nothing. The only thing is if you think your witnesses are going to be killed or whatever. Bad Vibe says you need a macro key that plays direct saying, these damn kids. I can actually make that. I'll get him to record it. All right. All right. This is the case in Pennsylvania. I talked about it on a short video early in the week when it was filed because I found it very, very interesting. And I said that this case, which has, let me be clear on this, because I can't say it enough. And people put comments on my videos like, go Rudy, go. Has nothing to do with Rudy Giullani in this case. People are like, yeah, the fraud is massive. This case isn't about fraud. There's nothing to do with fraud in this case at all. There's no fraud in this case. And it is still a better case than the fraud case was. This case is about the constitutionality of voting in any way other than in person in Pennsylvania in this election. That's what it's about. It's about whether or not they properly amended the law, or technically amended the Constitution, and then changed the law about how absentee or mail-in voting was done for the 2020 election. This lawsuit says no. A plain reading of the scenario says no. And we now have an appellate court judge. This is in Pennsylvania state court, not in federal court, because this is a state constitution issue and therefore properly is brought in state court. This case is far more interesting and a far better approach, in my opinion, than anything they've brought in a Pennsylvania court so far. Okay? This is a very, very interesting case. We need at least a hack/fraud in it. No. This case with no fraud has more likelihood of overturning the Pennsylvania election than any other case that they've brought in Pennsylvania, bar none. This is it, okay? I don't know that it will succeed because it's still got a huge ask. It's still got a big ask, but that big ask is up against the constitutionality of what happened. And that has a chance to go to the Pennsylvania Supreme Court, but also be appealed to the Supreme Court of the United States if the Pennsylvania Supreme Court rules wrong. So, we'll see. We'll see if it happens. I'm not saying this is a winner of a case. I'm saying that this case is better than the other cases that have been brought. So here we go. I'm not going to read this whole case, but let's talk about what is happening here. This is an action seeking a declaration that the universal mail-in ballot provisions of a law called Act 77, Act of October 31st, 2019, are unconstitutional, and an injunction prohibiting certification of the results of the November 3rd, 2020 election in Pennsylvania and or requiring any such certification to be rescinded and for other inappropriate relief. Act 77 is the most expansive and fundamental change to the Pennsylvania voting code implemented illegally to date. Under the act and the mail-in ballot scheme it implements, any and all qualified electors are eligible to vote by mail, and no justification needs to be provided. As with prior historical attempts to illegally expand mail-in voting by statute, which have been struck down going back as far as the Military Absentee Ballot Act of 1839, Act 77 is another illegal attempt to override the limitations on absentee voting prescribed in the Pennsylvania Constitution without first following the necessary procedure to amend the Constitution to allow for the expansion. Okay? So the parties are a bunch of Republicans versus the Commonwealth. Material facts. All right? Material facts. I'm not mixing any Blackpills into this one. I genuinely don't know how it will go. Not saying it will go bad. I think this one has the chance to go good because it's a constitutional issue and it's a pretty damn clear one. That's the crazy thing. And the main arguments against it are, well, but the last election used it. Okay. Actually, I don't think the last election did, but okay. Background Article 7 of the Pennsylvania Constitution provides two exclusive mechanisms by which a qualified elector may cast his or her vote in an election. One, by submitting his or her vote in propria persona at the polling place on election day. In propria persona at the polling place, okay? And two, by submitting an absentee ballot, but only if the qualified voter satisfies the conditions precedent to meet the requirements for one of the four limited exclusive circumstances under which absentee voting is authorized under the Pennsylvania Constitution. So, you have to have one of four excuses. That's what's laid out in the Constitution. Although, as amended, it removed all of those things. Mail-in voting in the form implemented through Act 77 is an attempt by the legislature to fundamentally overhaul the Pennsylvania voting system and permit universal no-excuse mail-in voting absent any constitutional authority. Pennsylvania Constitution since 1838 has required voting to be in propria persona at the election in the county in which an eligible voter resides. This principle has been upheld by the Pennsylvania Supreme Court in several cases, going back to the first major attempt to expand absentee voting in 1864. Over time, exemptions to in-person voting have been added to the Constitution through amendments, which include specific exceptions for military personnel, disabled veterans, religious observations, and other circumstances. 1967 marked the first of several recent attempts to amend the Constitution in order to expand the exceptions for which absentee voting would be allowed, beyond the previously identified classes of active military and veterans. In 1967, the legislature went through the formal procedure to amending the Pennsylvania Constitution. The 1967 amendment resulted in the addition of Article 7, Section 14, which holds the current provision outlining the limited circumstance under which an elector is permitted to vote without being present at the polling location. After following the constitutionally mandated procedure for properly amending the Constitution, the legislature then enacted election code provisions that allowed for absentee ballots to be cast in the 4 exclusive circumstances authorized under Article 7, Section 14. Article 11, Section 1 of the Pennsylvania Constitution established the mandatory procedural requirements that must be strictly followed in order to amend the Constitution. Okay? This is where it hinges. This is the entire point where this hinges and why this looks to be correct and why the provisions look to be facially unconstitutional. I did a shot at 500. Well, I did half of a shot at 500 likes. Let me do the other half. You get me to 1,000 and I'll do another one, okay? This is good because I need to reduce my liquor stock anyway. This is like a half, right? I think. Might be a little more. I don't know. Whoops. Woo. Okay. All right. So pursuant to Article 9, Section 1, a proposed constitutional amendment must be approved by a majority vote of the members of both the House and the Senate in 2 consecutive legislative sessions. Then the proposed amendment must be published for 3 months ahead of the next general election in 2 newspapers in each county. And finally, it must be submitted to the electors as a ballot question in the next general election and approved by a majority of those voting on the amendment. Since this bill was brought in 2019, the only way it could possibly satisfy these results would be if in the 2019 session it was passed, then again in 2020, then it went for 3 months prior to the election, published in a newspaper, and then was put on the ballot this year to be approved. That's the way this could have happened. But clearly, even if it was approved in this election, the provisions wouldn't be active for this election. And I want to point out, this is a Republican bill. The Republicans in Pennsylvania passed this. Democrats helped. This was a Republican bill that had a small amount of Democrat support. Remember, Democrats thought Republicans were going to defraud the election. Up until just recently, the Democrats were saying the Republicans were going to cheat. So the Republicans passing this and the Democrats being opposed to it were because Democrats were saying Republicans would cheat. Polio64 says, I just want to pop in and say, I'll never forgive you for these black pills and for being a Biden supporter. I'm unsubbing now, you grifter. Polio, no! Don't do it! Frederick Little says, at 1,000 likes, do a shot of Malort. No. I will not. I will not. Okay. So similar to previous absentee voting legislation found to be unconstitutional under Pennsylvania law, the legislature did not follow the necessary procedures for amending the Constitution before enacting Act 77. In 2019, the legislature recognized that there was no constitutional authority for the no-excuse mail-in voting scheme that it desired to implement through Act 77, and concurrently initiated the process of proposing an amendment to the Constitution in order to amend the Constitution provisions concerning absentee voting to allow for no-excuse mail-in voting. However, pursuant to the Pennsylvania Constitution, Article 11, Section 1, an amendment to the Constitution must be approved by a majority of the members of both the Senate and the House of Representatives in 2 separate legislative sessions, then submitted as a ballot question to be voted on by the electors. If, after approval by 2 legislative sessions, a majority of the electors then vote to approve the proposed constitutional amendment, only then will the amendment take effect. Although Act 77 has the effect of attempting to amend the Pennsylvania Constitution, it never went through the procedural requirements for such an amendment and has no legal effect. Neither Act 77 nor the contemporaneous proposed constitutional amendment initiated by the legislature have been approved by a majority vote of both the House and Senate in 2 consecutive legislative sessions, nor has either been submitted to the qualified electors as a ballot question and approved by a majority vote of the citizens. Despite the lack of constitutional authority to pass universal mail-in voting scheme, a scheme which far eclipses any previously conscribed absentee voting scheme, the legislature proceeded to implement Act 77 anyway in direct contravention of the Constitution. Put differently, the legislature first recognized their constitutional constraints and the need to amend the Constitution in order to enact mail-in voting, sought to amend the Constitution to lawfully allow for the legislation they intended to pass, and subsequently abandoned their efforts to comply with the Constitution and instead enacted Act 77 irrespective of their actual knowledge that they lacked the legal authority to do so, unless and until the proposed constitutional amendment was ratified by approval of a majority of electors voting on the proposed amendment. Mail-in ballot scheme under Act 77 is therefore unconstitutional on its face and must be struck down as void ab initio. Void as of its creation, basically. Mithrin Emrys says, politicians flip-flopping? Shocked I am. Fetch my fainting couch and smelling suns. Oh my word. Ah. All right. The reason I made a video early in the week about this is because this case is genuinely exciting. Like, what a crazy setup. And it goes back to something I've talked about several times. All of our government exists on an agreement that everyone just follows the rules and does the things that they're supposed to do. And the hard reality is that the way to break that is just to not do it. I've said this about Trump and executive power, and annoyingly, he never did it because I thought it would be funny sometimes. But, well, actually, he did once. Twitter told him to unblock journalists, but they didn't, or the judge told him to unblock journalists, but didn't order him to. And he just kind of ignored that, I believe. There was DACA, where they said you can't shut that down, and Trump said, I'm shutting it down anyway. You know, these are minor things, but really, if a president just decides to do something and a court says no, and then he says, yeah, I don't care. In theory, he actually can do it as long as people listen to him. And in this case, in Pennsylvania, they didn't have the constitutional authority to do it. But who stops them? They just did it anyway. Well, now they have to reap the consequences potentially. And those consequences may be the invalidation of every mail-in or absentee ballot that isn't accompanied by one of the 4 constitutionally mandated excuses. And if they didn't make people send in those constitutionally mandated excuses, well then, it may be too bad. And guess what happens if all of the mail-in ballots and absentee ballots in Pennsylvania go away? They lose. Joe Biden loses Pennsylvania. Doesn't lose the election, but he loses Pennsylvania. The most likely outcome is that it would go to the state legislature to then determine who the electors are. So, Angry Bainling, I've read all of the chats as they've come in. There's some $2 ones I haven't read yet. I've read all of them. Aren't you worried that the remedy will be going forward, we will do this? Yes. I am worried that that is a remedy the court could choose. I am worried about that. However, as the electors have not been fully picked, have not cast their votes, there is time to remedy it without doing that. So we'll see. Now, here's your doom pill possibility. Okay? Here's your real doom pill possibility. The state legislature of Pennsylvania could be ordered to pick the electors, and the Republican state legislature of Pennsylvania could vote for the Democrat electors, saying that they believe that the absentee ballots are accurate. And if you have ever had the hankering of calling a Republican a Recuckican, that is, I'm shocked to say, not out of the realm of possibility. And that would be grade A bullshit. They could do it. They could do it. There's no guarantee they will turn those electors to Trump electors. There's every possibility they will just say, well, we believe the results are valid, trying to save their own asses. It would be political suicide. Look, both ways are political suicide for them. So we'll see what they do. Well, we might not. I mean, the Supreme Court of Pennsylvania could shut this down. U.S. Supreme Court could refuse to take it up on cert. So who knows? Who knows? Bad Vibes says, quote, you are going to cheat. To no fraud here. The Janus factor is real. Janus, the two-faced god. Brian and Terrence says, I wish to make a public apology to brother Angry Bainling and what I made him go through tonight. Praise the sun. No, don't praise the sun. Angry Bainling wants you to praise the sun because the sun burns all the gingers. Mithrin Emmer says, bad Nick, no giving us a nice white pill like this and following it up with a massive doom pill. Look, it's only a doom pill if you don't have any faith in Republicans. Oh my God, what am I saying? Okay. So there's, how much time do I want to spend? This is the rest of the show. We're going to be talking mostly about this lawsuit, I think. Oh, I want to point out one more thing on Sidney Powell's lawsuit. Remember this? The District of Georgia, the District, they have fixed this. They have fixed this now. Here's the updated one. Whoops. Here's the updated one. But no, they have a random highlight stuck in here. So good job there. I don't know what that is. That's not me. That's them. But they have fixed this. They've cleaned it up a bit. Again, no filing number though. But they have cleaned it up, and it now says district instead of district. District! All right, back to this. You got any more white pills? Yes. Yes, they're coming. They're coming. Because this is back on the 21st of November. And I'll talk about what happened since. It's very, very exciting. This case is very interesting. The in progress efforts to amend the Pennsylvania Constitution to allow no excuse absentee voting. Do we need to read this? Yes, just a couple more, like 2 pages, and then we're gonna move on to what's happening in the case. Okay, so stick with me. In 2019, the Pennsylvania General Assembly again began the process for amending Article 7, Section 14 of the Pennsylvania Constitution, this time in order to permit absentee voting for all voters through Senate Bill 411-2019, later incorporated into Senate Bill 413. The legislative history of the proposed amendment recognizes that, quote, Pennsylvania's current constitution restricts voters wanting to vote by absentee ballot to specific situations. The amendment proposes to, quote, eliminate these limitations, empowering voters to request and submit absentee ballots for any reason, allowing them to vote early and by mail. Introduced in March 19, 2019, Senate Bill 413, as originally filed, was a joint resolution proposing an amendment to the Pennsylvania Constitution relating to judicial retention elections and containing nothing related to the Constitution's absentee voting provision. The bill passed out of the Senate on October 22, 2019, and was sent to the House, where it was referred to the House Committee on State Government a few days later. On April 6, 2020, Senate Bill 413 was reported as amended from committee. Senate Bill 413's caption was changed from the introduced version, which read, a joint resolution proposing separate and distinct amendments to the Constitution of the Commonwealth of Pennsylvania, further providing for tenure of justices, judges, and justices of the peace, to a joint resolution proposing separate and distinct amendments to the Constitution of the Commonwealth of Pennsylvania, further providing for tenure of justices, judges, and justices of the peace, and further providing for absentee voting. In its amended form, with the added provision seeking to amend the Pennsylvania Constitution's absentee voting restrictions, SB 413 was passed by a majority of both houses and filed with the Office of the Secretary of the Commonwealth on April 29, 2020. Senate Bill 413 will need to be passed by a majority vote in both the Senate and House of Republicans in the next legislative session, and then appear on the November 2021 general election ballot to be approved by a majority of the electors in order to be ratified and properly approved pursuant to the established procedures set forth under the Pennsylvania Constitution. If properly approved and ratified by a majority of voters, the amended section will read as follows, and here is the section. It's got the lined out stuff, which is being removed. Now, I'm going to read the lined out stuff so that we know what actually were the requirements, because I don't remember them. Qualified electors who may, on the occurrence of any election, be absent from the municipality of their residence because of their duties, occupation, or business require them to be elsewhere, or who, on the occurrence of any election, are unable to attend at their proper polling place because of illness or physical disability, or who will not attend a polling place because of the observance of a religious holiday, or who cannot vote because of election day duties in the case of a county employee. So, absentee ballots were allowed if your duty, occupation, or business required you to be away, you were unable to be there due to illness or physical disability, observance of a religious holiday, or because you're a county employee and you have to work the election, you get the opportunity to vote in a different, in absentee. That was the initial bit, and they've changed that. Now they want to say a law under this subsection may not require a qualified elector to physically appear at a polling place on the day of the election. So that is what happened. So then they point out that the resolution establishing the committee noted that the Commonwealth has traditionally only allowed absentee voting by individuals with a statutorily defined excuse to do so, such as a disability or absence from their municipality on election day. Further notes that before the enactment of Act 77 of 2019, for an individual to vote absentee in this Commonwealth, the individual must have provided a permissible reason to do so. It is acknowledged that Act 77 created a new category of mail-in voting, whereby mail-in voters do not have to provide a customary reason to vote by mail and are able to return their ballots several days later than had traditionally been allowed. As with every other amendment to the Constitution, it faces additional hurdles and requirements imposed by the Pennsylvania Constitution before it becomes law, and its changes have any valid legally binding effect. So they still need to approve it in the next session. Then it has to go to the general election as a ballot question. Unless and until the procedures for proposing and approving such an amendment are strictly complied with, the only lawful and constitutional methods of voting in Pennsylvania are in-person voting and absentee voting for those who qualify for one of the 4 exclusive limited circumstances under which absentee voting is constitutionally authorized under Article 7, Section 14. Okay. So, long story short. They're saying that they don't have the actual authority to change the law. Perpetuous Augustus says, if the prayer for relief in the Pennsylvania House that had the injunction upheld gets granted, does the Pennsylvania resolution have the authority to appoint electors? I believe, I don't know if they, how do I word this? I don't know if they used the mail-in balloting in 2019. If they didn't use the mail-in ballots in 2019, it doesn't matter. If they did use the mail-in ballots in 2019, then the entire legislature may not, at least the House of Representatives may not be valid. So, I don't know what they did in 2019. Then we have the November 3rd general election was administered by Pennsylvania's pursuant to Act 77. So, okay. So here's what happened. All right. They take this to court. And the judge grants them the injunction. But it's more complicated than that. It's more complicated than the judge granting them the injunction. So, the judge gave, how do I word this? The judge gave the defendants, all right, the Commonwealth General Assembly, Thomas Wolfe, the governor, and Kathy Boockvar, the Secretary of State. The judge gave them until 12:30 p.m. on November 25th to file their response. All right? Rather than filing their response at 12:30, somewhere around 11 a.m., they actually certified the election results. Rather than filing a response, they certified the election results early, and then they filed their response saying that the petition was moot because it was already done. If you did this in regular court, a judge may just shoot you. Okay? So, however, there are several steps to certification, and there may have been some steps that weren't complete yet. So what the judge did then was he said he was issuing the injunction, and he was issuing the injunction on whatever hadn't been done to perfect the certification. So I want to be clear, like, I've shit on Rudy Giullani a lot for that messed up case that they've got. But the Pennsylvania administration is absolutely trying to subvert the court process And they sure as shit make it look very, very corrupt. They sure as shit do. To the point where they say, Constitution doesn't matter, we already certified the results. Knowing with a high degree of likelihood that they would get this injunction, and it would prevent them from certifying the results if they waited. Last year, they certified their results on December 12th. Or last year, in 2016. In 2016, Pennsylvania certified its results on December 12th. There was no reason for them to certify on November 25th other than to beat the injunction that they knew was probably coming. Because this complaint right here is actually terrifying for them, because it doesn't say that anyone did anything nefarious. It just says that this can't legally occur. And that is the scariest type of challenge. Because no one has to be a bad guy, right? No one had to go, we're going to change the vote. They didn't have to do that. You don't need a villain in this story. If you're painted as a villain, you can just call the other people lunatics. You say, oh, they've got prejudices, they've got biases, they're after me, blah, blah, blah. These guys aren't even blaming the governor and the secretary as much. It's really the legislature that did it. I mean, sure, the governor signed it and then it was recorded as having the effect of law. But no one's really the bad guy here. They don't have to be. And that is scarier. In the other cases, you've got almost cartoon villain levels of conspiracy and screwing around, horsecockery. You have to reconcile this in the mind of a judge or a jury or whatever it ends up being. You have to get the, I'm trying to steal an election. With this case, you don't need that. You just say, hey, by the way, it's supposed to be constitutionally amended and they didn't do that. So, nope. And no one had to, that's just a mistake or an error. So this is why this case is scary to them. They're not the villain. That's why I like this case way more than the other case. The moment I read it, I was excited about the possibilities. And then, of course, the other possibilities are, what the hell happens if they win? I mean, if they're right, the judge really has to prevent certification in the traditional manner. They have to kick it to the legislature. Because it was constitutionally impermissible. And then it casts doubt on the results of the election. I mean, I guess the other remedy would be to throw out the mail-in ballots and just award it to Trump. Certify the non-mail-in ballots. I don't know that they'll do that. I mean, maybe they would. I don't know. That's what's exciting about this. And then, of course, a judge that is trying to grow back a soul or whatever says, I can't do this to all these voters. I don't know what to do. Very, very weird stuff, right? There is another option. There is another option that is a weird, this would be a weird one. But okay, hear me out. Since the Constitution of the United States leaves all of the power to determine state elections in the hands of the state legislatures, it is theoretically possible that the state constitution cannot bind the state legislature from setting election procedures. You follow me on that? I'm not saying that that's the case. I'm saying that that would be a way out for the judge. And I don't know the answer to that. It seems ludicrous that a state constitution couldn't bind a state legislature. But if the judges said potentially that no, Congress, through the United States Constitution, which is the ultimate authority here, and then this becomes a federal question for the Supreme Court of the United States. That's the white pill cherry on top of this doom pill, okay? And because this sounds like a doom pill, but I'm really just in real time exploring the possibilities. Possibility is that someone says, well, because the Constitution grants this authority to state legislatures, a state constitution can't bind and restrict that authority. It doesn't have the power to. But then the counter argument is that the state constitution is enacted by the state legislature. Therefore, it's not being bound by something other than the state legislature itself. Therefore, it has the power to bind the state legislature. All right. So it's a very weird sort of back and forth argument. And the question would be, is if it went to the U.S. Supreme Court, how do the chips fall? I think they fall on this being unconstitutional. So I think, the way I've seen this case every time is they have to. They have to throw it out. I don't know that they will. Okay, I'm not making a prediction because I genuinely don't know what you do. This shouldn't have happened in the first place. But it seems like you got to throw out the mail-in ballots, at the very least, you got to throw them out. They're not allowed to exist. Man, it's tough. R.W. Bimby says, state constitution at leisure of legislature amendments. Yeah, that's the argument, right? The legislature is the vehicle which defines the state constitution. Therefore, they're binding themselves. They've delegated their own authority to a constitutional document, and they've removed some things from the easy legislative process. I mean, that's what I would say. Bad Vibe says, wait, so constitutional law is legislative cuckery? I mean, well, yeah, I guess. Anyway, so sorry. Back to the I got lost in musing on this really, really interesting case. Back to the procedure. What happened? The judge issues the injunction on the remaining steps for perfecting certification. Perfection is a process by which something that is a legally operative function is completed and given full legal status. So in many states, for example, if you buy a house, right? If you buy property, then your purchase is only part of your ownership. They would give you a title, and in many states you have to take that title to a county recorder and record the title. And the recording of the title perfects your legal right, your legal ownership of the property. Same thing with like a lien on a car. You can grant a lien on your property to a lender, for example, in exchange for some cash, and that lender can write up the lien, sign it, have you sign it, but in some places they will have to have some extra step involved in perfecting that lien. Typically, it could be recording the lien on the title of the car at the Department of Motor Vehicles. Okay, so that perfection step appears to have not taken place in Pennsylvania, so the judge put an injunction on completing those perfection steps. And then what he did was he set a hearing for today, Black Friday, the 27th of November. He set an evidentiary hearing on the matter. That was the last I heard of it. Turns out another update happened on the 25th after that. Rather than go to that evidentiary hearing, the governor and the Secretary of State Boockvar appealed this to the, to the appeals court of Pennsylvania, the state appellate court. So they did that. A matter, I believe, 3 hours after the injunction was issued, they appealed it to the state appeals court. And then in doing so, they invalidated the injunction. So that was great. They invalidated the injunction. So then on the 27th, the evidentiary hearing was canceled. Okay? Then what happened just this evening, all right? Just this evening is this. This is the Commonwealth Court of Pennsylvania. Honorable Patricia A. McCullough is the judge. This opinion was not reported. This was filed today. All right? So this is the white pill. As this court's November 25th, 2020 order of an emergency preliminary injunction has been appealed to the Pennsylvania Supreme Court, this opinion shall set forth the basis for said order and shall also satisfy the requirements of Rule 1925 of the Pennsylvania Rules of Appellate Procedure. The overarching consideration for the emergency preliminary injunction pending the evidentiary hearing scheduled for November 27, 2020 is the compelling exigencies raised in this case, which are of statewide and national concern. Petitioners raise matters that go to the core of the electoral process and involve the constitutionality of how the citizens of this Commonwealth may cast their votes, not only for the offices sought by petitioners, but also for the office of the President and Vice President of the United States of America, as well as statewide, regional, and local offices. Now, a bunch of people have been out on Twitter and other things saying, oh, but this only affects down ballot races. It doesn't affect the presidency. Wrong. You're fucking wrong. It's been wrong. This injunction applies to every ballot. Okay? So whoever said that, you're incorrect. It was never that. In fact, there were two distinct parts of the injunction, one that dealt with the presidential election and one that dealt with literally everything else. And that's because there are two constitutional ways to determine it. The presidential election is covered in Article 2, Section 1, Paragraph 2, I guess, of the Constitution. And the legislature and the state legislature and all that is dealt with in Article 1, Section 4, Paragraph something. So they're two separate things. Presidential elections are different. And that's why I've said a couple times now, they can't do a revote on the president. Can't do it. It has a different constitutional provision than everything else. So the order itself was in two parts. So anyone who said it didn't apply to the presidential election, they were wrong. Okay. But anyway, on November 21st, 2020, the Honorable Mike Kelly, Sean Parnell, blah, 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 filed a complaint for declaratory and injunctive relief in this court against the Commonwealth of Pennsylvania, Pennsylvania General Assembly, and Thomas Wolfe and Kathy Boockvar, which this court indicated it was treat as a petition for review addressed to the court's original jurisdiction. In the petition, petitioners alleged that the act of October 31st, 2019, Act 77, which added and amended various absentee and mail-in voting provisions in the Pennsylvania Election Code, is unconstitutional and void ab initio because it purportedly contravenes the requirements of the Pennsylvania Constitution. Petitioners allege that Article 7, Section 14 of the Constitution provides two exclusive mechanisms by which a qualified elector may cast his or her vote, impropria persona, at the polling place on election day and by submitting an absentee ballot, but only if the qualified voter satisfies the conditions precedent to meet the requirements of the one of the four blah, 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 blah. We already read this. Petitioners allege that mail-in voting in the form implemented through Act 77 is an attempt by the legislature to fundamentally overhaul the voting system and permit universal no-excuse mail-in voting absent any constitutional authority. Petitioners argue that in order to amend the Constitution, mandatory procedural arguments The requirements must be strictly followed, specifically pursuant to Article 11, Section 1. We've read all of this just a minute ago, and they're borrowing this from their complaint. As relief, they seek, among other things, a declaration and or injunction that prohibits respondents from certifying the 2020 general election results, which include mail-in ballots that are permitted on a statewide basis and are allegedly improper because the act is unconstitutional. On November 22nd, petitioners filed a motion for emergency special prohibitory injunction and a memorandum of law in support of the emergency motion. In the emergency motion, petitioners seek to enjoin respondents from taking official action to tabulate, compute, canvass, certify, or otherwise finalize the results of the November 3rd general election. Are you still calling me a doomer? Socialism is for figs? Rude. They submit that this court must intervene immediately in order to prevent irreparable injury from the resulting wrongs of an election conducted pursuant to an unconstitutional and invalid mail-in ballot voting scheme. They claim their right to relief is clear and they are likely to succeed on the merits because they have showed that a substantial legal question must be resolved to determine the rights of the parties. They contend that the Pennsylvania Constitution requires voting to take place in person, subject only to specified exceptions. They point out that Article 7, Section 14 provides the only such exceptions in the impropria persona voting requirement of the Constitution for specific circumstances. We read that. Petitioners argue that outside of the aforementioned prescribed situations, Constitution does not provide a mechanism for the legislature to allow for expansion of absentee voting. Consequently, Act 77 is illegal and void ab initio because it attempts to expand the constitutionally established exceptions in impropria persona voting. According to petitioners, they did this by creating a false distinction between existent absentee voting and mail-in voting, and absentee voting is only constitutionally authorized under the four limited circumstances specifically delineated in Section 14. So what they're saying is that Act 77 creates a new type of voting, mail-in voting, which is not under the Constitution of absentee voting. Petitioners contend that that's what the opponents are saying. Petitioners contend that without an immediate temporary injunction, Pennsylvania's electoral votes will be cast, electors will be appointed, and this court will lose any authority to provide relief to petitioners. Now, I want to point out one more scummy thing that Tom Wolf did. One more scummy thing Tom Wolf did and Secretary Bookvar is they said that if the evidentiary hearing on the 27th were allowed to occur, that it would delay the ability for them to certify the election. Even though the injunction was set to expire on the 27th, they said that the injunction would prevent them from certifying the results and sending electors. Which is a lie. Okay, it's a lie. That's what I'm saying. They just lied. So, Tom Wolf and Secretary Bookvar are giant pieces of shit, and they deserve to eat themselves. All right. Petitioners contend, that the electoral votes will be cast, electors will be appointed, and this court will lose any authority to provide relief to petitioners. Yes. Petitioners argue that greater injury will result from allowing the certification of results pursuant to an unconstitutional no-excuse mail-in voting scheme than from prohibiting it. Specifically, they contend that no voters will be disenfranchised by the result of a slight delay in certifying the results. Conversely, because yes, they can certify the results as late as December 12th. Conversely, they argue if the limited injunction is not granted, the harm to all Pennsylvanians is irreparable because it will suffer the fruits of an unconstitutional election. By order of November 22nd, 2020, this court observed that petitioners had not properly served the petition upon respondents, directed service of the petition, and the court's order in accordance with Rule 1514 of the Rules of Appellate Procedure, and further directed that petitioners file proof of service thereof with the prothonotary by 10 a.m. Monday the 23rd. Upon the filing of proof of service, the court scheduled an expedited telephonic status conference with all counsel of record and unrepresented parties for November 23rd at 3 p.m. When the status conference convened in the matter, the Secretary of the Commonwealth and Governor had not certified the results of the November 5th election. Indeed, during the course of the status conference, counsel for respondents said to this court that the Secretary was only in the process of certifying the results of the election. By the way, this line matters because I'll tell you what courts really, really hate is when you try to get cute. Well, Judge, I haven't certified them yet. Right? Like some sort of gay Sailor Moon villain or something. No. Don't be cute with the judge. If you say, well, Judge, we haven't certified it, but we're going to by this date, you know what would have happened? Yeah, no, don't do it. Do you have to? Why are you doing that now? Can it wait a day? Can it wait 2 days? Oh, we're only in the process. Rush to get it done. So anyway, I just wanted to point that out. Every game played says if they throw out the ballots, another question is what do they do for the other offices / ballot measures being voted on? It is a question, isn't it? They can do a re-election or a special election on all of those things, actually. There's no... only the president cannot have a re-election. In fact, in theory, the governor, you know, if somehow the legislators weren't able to do the re-vote or whatever, I believe the governor could fill the vacancies of the legislature until the time of a special emergency election. You know, all of that can happen if necessary. Everything else could be pushed to a special election, a redo. Following the status conference with counsel, the court entered an order on November 23, 2020, directing respondents to file preliminary objections, directing to the DNC Services Corporation Democratic National Committee, proposed intervener, to file an amicus curiae brief in support of its proposed preliminary objections filed with the court, and further directing petitioners to file answers and briefs in opposition to the preliminary objections. The parties were asked to specifically to address the application of Section 13(1), 2, and 3 of Act 77, and whether a party is permitted to challenge the constitutionality of Act 77 in any court subsequent to the expiration of 180 days. Per curiam order, November 23, 2020. Pursuant to the court's November 23, 2020 order, Pennsylvania General Assembly filed its preliminary objections and a memorandum of law in support thereof, and Secretary Kathy Bookvar, the Honorable Thomas W. Wolfe, and the Commonwealth of Pennsylvania together filed preliminary objections and a brief in support thereof. Proposed intervener has filed an amicus brief in support of its preliminary objections. By order of November 24, 2020, this court, upon further consideration of the emergency motion, ordered respondents to file and serve answers to the petitioner's emergency motion and directed that proposed intervener may file a brief as amicus curiae in opposition to the emergency motion by 12:30 p.m. on the same date. So this is November 24th at 9:37 in the morning. They ordered them to respond by 12:30. Petitioners complied with this court's order and filed answers and briefs in opposition to General Assembly's and Executive Respondents' preliminary objections. General Assembly and Executive Respondents have filed their respective answers to the emergency motion, and Executive Respondents also filed a brief in opposition to the emergency motion. Finally, proposed intervener filed an amicus curiae brief in opposition to the motion. The petitioner's emergency motion was thus ripe for disposition by order and opinion. However, the very next morning after the status conference, on November 24th, 2020, the Executive Respondents filed a brief with an appended press release dated 11/24/2020 from the Department of State. The press release stated that following certification of the presidential vote submitted by all 67 counties late Monday, the Secretary today certified the results of the November 3rd election in Pennsylvania for President and Vice President of the United States. The press release, as well as the respondents' briefs, assert that certification only occurred regarding the results for President and Vice President. Based on this information in the press release, respondents argue the entire dispute is moot. A review of the department's website did not contain any additional information regarding the status of the certification process, nor the entry of any formal public record of such certification. Also, nothing was entered regarding certification of the election results. On November 25th, 2020, petitioners responded to executive respondents' brief. Oh, this is a long thing. Hold on. Bad Vibe says if certification is not complete in Pennsylvania, then what happens? Pennsylvania, if certification doesn't occur, then the Pennsylvania legislature has to send electors, or they don't get to have their electoral votes counted, which means they don't go to Biden or Trump. Mithrin Emrys says, I, Nick Rekieta, hereby promise that if I hit 1,000 likes tonight, I will cosplay as Tuxedo Mask for the next time I stream with Drexel. That is a filthy and dirty lie. I will not. I will not. Okay. On November 25th, 2020, petitioners responded to executive respondents' brief in opposition to motion for emergency injunction and press release by filing a supplemental application for emergency relief, which raises additional compelling concerns and questions of fact in support of their underlying petition for review regarding the formal requirements and status of the certification process and whether respondents might have short-circuited the certification process to purportedly avert this court's determination on the merits by declaring victories in the presidential and vice presidential elections while leaving certification of the elections for the other offices for another time. Petitioners, yeah, that's the other thing. They only certified the presidential and vice presidential elections. All the other ballots, though, they didn't certify those results. And they also, the Republicans did allege, or the petitioners alleged, that they had not done the perfecting steps. And they listed like 7 or 10 steps. Okay. Petitioner's supplemental application for emergency relief also raises the issue of whether the results of an election can be certified piecemeal. It is also noted petitioners allege that notwithstanding respondents' press release, the dispute was not moot because the certification process for the presidential and vice presidential elections had not been perfected because there were additional steps that needed to be completed, including issuance of commissions to persons elected pursuant to this statute, issuance of certificates election, and transmission of such certificates to the Speaker of the House of Representatives of the U.S. in the case of the election of representatives in Congress pursuant to a different statute, issuance of certificates of election to the persons elected members of the Senate and House of Representatives of the Commonwealth, and presentation of the several returns of the same elections before the Senate and House of Representatives, delivery of the returns of elections for Auditor General and State Treasurer to the President of the Senate so that they can declare elected thereto, the making and filing of certificates for all such elections, the issuance of commissions for all such elections, and the issuance of commissions for each election of judge of every court pursuant to statute. Issuance of certificates of election to successful candidates of elections pursuant to this statute. Delivery of certificates of election for each presidential and vice presidential elector pursuant to another statute. Okay, that's a lot of boring. Long story short, bunch of stuff that they haven't done yet. Come on, guys, get me to 1,000 likes so I can get another drink. Accordingly, in careful consideration of the exigencies and time constraints in this matter of statewide and national support or import and the long-standing constitutional mandate that every citizen of this Commonwealth is entitled to no less than a fair and free election, it was necessary to preliminarily enjoin, on an emergency and temporary basis, executive respondents from undertaking any other actions with respect to the certification of the results of the presidential and vice presidential elections, if indeed anything else needs to be done, pending an evidentiary hearing to ascertain the facts of this matter and determine if the dispute is moot. We're still back a couple days ago. Oh, there it is. Lefroig. Baron Wolfsbane says, I, Nick Rekieta, most certainly did not lie and will cosplay as Tuxedo Mask the next time I stream with Drexel because I love Tuxedo Mask, my favorite. Oh my God. Socialism is for figs. Says, Nick, if Trump wins this, and I don't care how he wins this, by the way, civil or uncivil, I want you to eat your words, and you must speak in Kermit voice for a month of streams, but you are still a doomer boomer. Which words do you want me to eat, buddy? We'll have it. We'll have it happen. Lafroig is not a shooting whiskey. Oh. Easis Donic Dom says, get ready to perfect your poetry for the cosplay, Nikki. Tell you what. If Trump wins, we'll do an episode of how to catch and convict a pedophile or predator or whatever. Damn it. And we will, not supposed to say that word. A child fanatic, and we will I will read all of the dirty parts of that case in Kermit voice for you. Kermit and Elmo voice if there are two parties to the dirty talk. So, there you go. Like, hey there, little fella. I'd like to diddle your bunghole.
Oh, hey, thank you. I like diddling.
Gross. All right. Now Trump has to win. Inasmuch as the secretary had not certified the remaining results of the 2020 general election, it was also necessary to enjoin on an emergency and preliminary basis any attempt to certify these results as well. In light of the factual, constitutional, and legal issues raised, it was incumbent upon the court to immediately enter such emergency preliminary injunction to maintain the status quo and ensure that all the parties and the citizens of the Commonwealth of Pennsylvania were not denied their right to a free and fair and free election. This is something that I don't think the other cases focused on well that I've seen. There is a right to a free and fair election. I guess it's still, I don't know, maybe it's still not specific enough. Never mind. Based upon the record before it, this court has sufficient grounds to enjoin respondents from further certification activities on an emergency preliminary basis, pending the results of the evidentiary hearing it had scheduled for this date, after which the court would have determined if a preliminary injunction should issue. Since the court is sitting in equity, it has the power to fashion such relief as it is vitally important to the status quo, or that the status quo be preserved pending further judicial scrutiny. There is no harm to respondents by the relief fashioned by this court. The safe harbor provision of 3 U.S.C. 5 does not expire until December 8th, 2020, and the Electoral College does not vote for president and vice president until December 14th, 2020. Additionally, petitioners appear to have established a likelihood to succeed on the merits because petitioners have asserted the Constitution does not provide a mechanism for the legislature to allow for expansion of absentee voting without a constitutional amendment. Whoa! That's not fucking good, is it, Tom Wolfe, you piece of shit? Uh-oh! Petitioners appear to have a viable claim that the mail-in ballot procedures set forth in Act 77 contravene Pennsylvania Constitution Article 7, Section 14, as the plain language of that constitutional provision is at odds with the mail-in provisions of Act 77. Since this presents an issue of law which has already been thoroughly briefed by the parties, this court can state that petitioners have a likelihood of success on the merits of its Pennsylvania constitutional claim. Yo, Oh my goodness. Did I not promise you white pills? Did I not promise you a white pill? And by the way, to the gay idiot on Twitter with the stupid shark profile who keeps screaming about latches like some retarded dolphin, you have no idea what you're talking about with latches. But now, several Pennsylvania judges, several of them, have suggested that this lawsuit has merit. Why don't you go bother their Twitters about latches, you moron? Anyway. Latches is the idea. It's not an idea. It's a principle of law that something should have been raised earlier and that now it is no longer able to be raised. The idea, it's a rarely invoked thing, although it has been invoked in other cases in Pennsylvania, in Georgia, because some of the claims they just should have brought earlier. However, it rarely attaches to a constitutional issue. Because if it's not constitutional, then it's not constitutional. You can't just say, well, it's not constitutional, but this is how we're doing it. I mean, in theory, you can say that, but you can't say, well, they should have challenged it earlier, so now the thing that's not constitutional, I guess, just is. Anyway. They met a this is a high bar, showing a likelihood of success on the merits. It's not a possibility of success, it's a likelihood. Technically, they're winning right now. So, there you go. Without the emergency relief ordered by this court, there would be the likelihood of irreparable harm to petitioners, as to Petitioner Kelly. Although it appears that he gained the most votes in the election for the office he seeks, that result is yet to be certified. Yeah, so interestingly, one of the petitioners was winning the election. Further, he may suffer irreparable harm prospectively should he seek election to public office in the future. If what may be an unconstitutional mail-in voting process remains extant, such mail-in ballots may make the difference as to whether he is successful or not. As to petitioners Parnell and Logan, mail-in ballots may have made the difference as to whether they have won or lost their respective elections. Hence, their fates may well turn on the constitutionality of Act 77. The other voters in this case assert their constitutional voting rights as citizens of Pennsylvania would be irreparably harmed. Conversely, since the relief ordered by the court is on an emergency basis, respondents face no irreparable harm. In any event, the matter of irreparable harm would have been assessed at the evidentiary hearing. By the way, this right here, this line goes back to that other line that I said was important. You guys are trying to fuck around with the court. And the court they don't like it. I'm telling you, they don't like it. Candor before the court is in the rules of professional conduct for lawyers for a reason. The court doesn't like horseplay, horsecockery, or anything like it. They want you to just be honest. And if you're at all dishonest, they get pissed. Okay. Okay, I got some shit. Javier Miedo says, is the rejected appeal by Trump team in Pennsylvania today mean this suit is moot, or is this a separate case? This is a separate case. This is not the Trump team. This is an argument the Trump team should have been looking into and did not. Thank goodness these guys brought it. These are legislative candidates in Pennsylvania. And so they have brought the case. It has nothing to do with the Trump case. Also, how would U.S. states separate from country work. I don't know what you mean. Like, you mean leaving the country? You have to have permission of, you have to have basically a constitutional amendment. It's similar process to amending the Constitution to get a state out of the Union. Siren Jack says, my name is Nick Rekieta. And at 1,500 likes, I am drinking that coffee whiskey that I've been putting off for 3 days. Get me there, bitches. I do not want to drink coffee whiskey. Please do not make me drink coffee whiskey. I hate coffee, and it will be terrible. That is Lady Rackets' coffee whiskey. Don't make me do it. Not one of us says, how did you end up as a lawyer and not a voice actor or comedian? Jesus Christ. I don't know. Poor fate, I guess. Archimedes says, hey, Nick, Tim Pool just posted a screen grab. Send it to your Twitter. Is this the case you're going over right now? Take a quick look. Yes. Yep, that's the case we're covering right now, Archimedes. The Flying Jackman says in Kermit voice, gee, Bert, why does this boomer lawyer think I sound like a frog? Come on. You're trying to be Ernie, but Ernie's a little bit different. They're similar, but Ernie's a little bit different. He's a little softer, a little bit more swollen, if you know what I mean. Kofi 2A wannabe Hunan Muhammad says, I, Nick Rekieta, will have Drexel cosplay as Tuxedo Mask, and I, Nick Rekieta, will cosplay as Sailor Moon, and then we will have a child together. Oh, no. No! Bad Vibe says, likely because the judges are smart or boomers and don't have Twitter accounts. Lido Enchanted says, plug my VTuber channel. I, too, have been known to blackpill on stream and play as good as DSP in fighting games. Well, isn't that just turning the game off? And Othamer says, don't piss on the judge and tell him it's raining. Exactly. Exactly. All right. The relief ordered by this court is also in the public interest. Any claim that the voters of this Commonwealth are disenfranchised by this court's order are spurious. The order at issue does nothing more than preserve the status quo, pending further and immediate review. That being said, this court is mindful that one of the alternative reliefs noted by petitioners would cause the disenfranchisement of the nearly 7 million Pennsylvanians who voted in the 2020 general election. Specifically, respondents claim that a temporary stay would disenfranchise voters as the legislature would appoint the electors to the election college. However, as noted, the legislature is not authorized to appoint the electors to the Electoral College until December 8th, the federal safe harbor date for certifying results for presidential electors. The court agrees it would be untenable for the legislature to appoint the electors where an election has already occurred if the majority of voters who did not vote by mail entered their votes in accord with a constitutionally recognized method. As such, action would result in the disenfranchisement of every voter in the Commonwealth who voted in this election. Interestingly, the judge is not correct here. Maybe I'm reading it wrong. Not only those whose ballots are being challenged due to the constitutionality of Act 77. However, this is not the only equitable remedy available in a matter which hinges upon holding a most basic constitutional right of the people to a fair and free election. Hence, respondents have not established that greater harm will result in providing emergency relief than the harm suffered by the public due to the results of a purportedly unconstitutional election. So even here, this judge is not inclined to remove all of the votes. It sounds like the remedy that this judge has in mind, the remedy they have in mind would be to disregard only the unconstitutional votes. For all of the above reasons, the court respectfully submits that the emergency preliminary injunction was properly issued and should be upheld pending an expedited emergency evidentiary hearing. Okay, here we go. This is an interesting footnote. U.S. Supreme Court has addressed various circumstances concerning disenfranchisement of votes. For instance, it has held the right to vote is foundational to our republic, and this fundamental right, quote, can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. Reynolds, which established the one person, one vote doctrine, is the seminal case on voter dilution. Under this concept, a mail-in voting process that would exceed the limits of absentee voting prescribed in the Constitution could be construed as violating the one person, one vote. In that event, the sheer magnitude of the number of mail-in ballots would not be a basis to disregard not only this provision of the Pennsylvania Constitution, but also the one person, one vote doctrine established by Reynolds, one of the bedrock decisions of the U.S. Supreme Court. So here is just what I was saying. What they're saying here is that we're not willing to throw out every vote. We are, however, fully prepared to throw out the mail-in votes if they're unconstitutional. And the fact that there were a lot of mail-in votes is not sufficient to overcome the idea that one person gets one vote. So, very interesting. Very interesting. They're geared up to act on mail-in votes. What the Republicans should prepare for in this case is the idea that they will need to still show, as best they can that there are enough votes in question to overturn the election. And that means that if there is, I don't know about Pennsylvania, but if there is a provision that allowed people to give their still valid absentee reasons for getting their ballot, that is not at issue here, right? They should also be prepared to argue against the fact that it says they can vote by absentee ballot for physical illness or disability. All right? They should be prepared to argue against the obvious counter-argument that COVID created a physical illness and say that no, COVID is not a physical illness unless you've actually got it. And these people did not assert that they had it. Therefore, we can't take that. They should be prepared for these types of arguments. They should also be prepared for arguments that the emergency measures of COVID necessitate a temporary allowance to vote absentee or a temporary or truncated measure to amend the Constitution. These are the types of counter claims, contrary claims that you'd expect to see. These are the obvious ones. There are going to be other things saying where, oh no, they totally did amend the Constitution. They should also prepare for the argument that's already been brought up that this just creates a new type of absent voting, not absentee but mail-in, and those are different. They've got to be ready for that. Rational Redneck says all these white and black suppositories are exhausting. Keep up the good work. It's nice getting a fair opinion. Well, that's that. That's the white pilling today. I think this is I got to tweet this out. Let's see, where is it? Where was likelihood of success? Here we go. Look at that steady hand. Whoa. All right. Sorry. Very important that I make this right now. It's got to go. It's got to go out on Twitter. Go based PA judge. Raffle. There we go. Tweeted. Oh my goodness. That is a beautiful piece of the document right there. Snipping tool is great. This is actually my favorite inclusion of Windows 10. I don't need that. GTFO. Real Catnip Dave says, I am disabled Pennsylvania resident. We have to apply for a mail-in ballot, but this year it was sent to me without the application step, and everyone on my street, regardless of health, was sent it. There you go. There you go. Look, snipping tool may have been Win 7, but I only use it in Win 10. Shift Windows key S. That seems like I'm going to get my System 32 deleted, so I don't try that. Bad Vibe says, okay, so how does one differentiate between allowed absentee votes versus unconstitutional ballots? Well, you can only do that if the procedure for voting absentee allowed people the option to inform the state as they would have in past elections. Like Catnip said just a second ago, in prior elections, you had to apply. You had to apply for your absentee votes, and then in this election, they didn't. So if they didn't have to apply, that means they don't get to. They don't have a thing that'll allow them to say why they got it. So it'll just go away. Shift Win S is just a faster way of taking screenshots. Oh. So there you go, guys. Very interesting case. Big updates. The biggest of updates. The biggest of updates, having this preliminary injunction upheld, going to the appeals court. Because, okay, so what they did, like I said, was they immediately appealed it to take away the authority of the preliminary injunction. Because they're scumbags. That's what they were trying to do. But the court came in and said, yeah, no. You still have to. You still have an injunction. That's it. I don't know what else to tell you. We're gonna end this. We're gonna end this stream on white pills, man. This is Pennsylvania. Here's the thing. In all of these states, Trump basically needs Pennsylvania and 2 other states that he doesn't have, that aren't Maine or something. Pennsylvania, if they can flip it, that's huge. If they can flip Pennsylvania, Arizona, and Nevada, I think that's enough. Nevada. 6 there. 9, 15, 20, 35. 86 minus 35. Or wait, no. 306 minus 35. Oh, that might not be enough. That might be like 1 short. They might have to do another state. I don't know. They're trying to flip Wisconsin. Wisconsin is in turmoil. There's the Georgia and Michigan stuff with the Kraken. I wouldn't put a lot of faith in the Kraken. I wouldn't put a lot of faith in the Kraken. The Kraken is likely devised for the purposes of building support. I don't know what else to tell you on that one. I wouldn't put your faith in the Kraken. But here's the one thing I will say. The amount of people complaining at me about doom pilling or black pilling, the amount of people, Republicans out there and conservatives out there who believe that Joe Biden is not the legitimate president, the amount of Democrats out there that believe that Joe Biden is not the legitimate president is staggering. And if ever Republicans had enough support to actually do the drastic steps needed to change the electoral vote, it's now. It's now. Whatever the outcome in the courts are a more... They shouldn't be, but they're a more publicly legitimate way to do it. The actual legal legitimate way to do it is to really get the state legislatures to invalidate it. Shockingly, that's the system the founders built. The court system is like not actually geared for the political questions in the way that the political system is geared for it. But we're so far divergent from how the founders thought on these issues that we go, oh man, if the state legislatures did this, they're horrific people stealing the election. It's like, well, no, they're not stealing the election. That's like you have a badass remote control car and you're 11, right? You are now a state legislature. And you have your badass remote control car and you look at your friend and your friend's name is all of the citizens who can vote. And you hand that car to the citizens who can vote and you go, here you go play with it. And they drive that thing all over and they're having a good time with it. And you go, okay, I need to have that back now. I need it for a minute. And you take the controller from their hand and you drive the car. That's not stealing the car. You have the car. It's yours. You are letting them drive it. When they started being stupid and driving towards a lake or whatever, you took the controls back and you drove it the way you wanted. That's how it's supposed to be. That's how it was written. But now we look at that and we say that's stealing. So, but that's what matters is how we look at it now. So it's kind of it's a weird conundrum that we have, but it's the system and the preferences that we deal with. That's all we've got. So yeah, I don't know. Like I said, what I want to get out though is if there is a possibility for the state legislatures to do this in the modern era, it's now. They have actually a majority of the country, believe it or not, according to a recent study, a majority of the country believes that Joe Biden is not the legitimate winner. That means it's the overwhelming majority of Republicans and a significant minority of Democrats also believe it. Also, we know who actually stole this election, and it was the media. Specifically by suppressing the Hunter Biden story. I don't know if you guys saw this, but the Hunter Biden story in polling data suggests that 16%, a full 16% of Democrats would not have voted for Joe Biden if they knew about the Hunter Biden story. Twitter itself, Twitter and the media blackout fully took the election. So there you go. But we will see what happens. That's the best part. We always get to see what happens. Javier Miedo says, who's the worst lawyer you've encountered after considering Vic, Landau, 2020 election, etc.? Landau is still the worst lawyer. Because he's also, like, he's an actual dickbag. Also, conspiracy theory, Landwy is lawyering for the election. God, please no. Please no. Vexner says, heart your content. Ooh. Have a friend in law school who doesn't have time for your streams. Can you please make a short form straight facts vid detailing how Trump could still win? Appreciate you either way. Maybe. I don't know. I don't know. I don't like the here's how so-and-so can still win. It was really pitiful with the Bernie Sanders meme. I'm not sure if I will do that or not. We'll see what next week brings. Brian Natarin sent a chat, but it was retracted. And then he says, I call my Johnson the Kraken, so when I whip it out during sexy time, I can say release the Kraken. There you go. Doomer if not. Thank you, Vexner. Thank you. Okay, let's read through. There's a couple chats. Not as many because we did the Black Friday special. I'll have to come up with a Cyber Monday special too. We did the Black Friday special and got most of them done on the fly. But let's finish up the chats, and then we will go over to Twitch, watch some movies. Where were we? Oh my goodness! Felipe Mouve masked me. Joseph Kerwin says, Nick wrote a Sailor Moon romantic fanfic in which Nick played the role of Sailor Moon and Drex was Tuxedo Mask. I'm not saying it didn't happen. Kermit the Frog says, hey there, friends. Here's a free survival tip for you. If you are out camping and your friend gets bit by a snake, what's the first thing you do? Suck out the poison. But what they don't teach you is with your free hand, jiggle the man's balls. Yes, ball jiggling. Tess Not on Holiday says, Trump is legally required to lose now. How to Catch and Convict a Predator are the only shows worse and unfunny than Ronversations by Proxy. I haven't done one in so long. Those are not funny at all. They're entirely depressing. Angry Baneling says, don't want no mo doom pills. Get me hope. Give me hope, senpai. I don't know if you've gotten hope today, but we've gotten good news. Fenrir Lycros says, can you white pill me more and reply to the email I sent you on the 21 sometime later during the day? Maybe. Versi says, what, in your opinion, would be qualifying evidence of voter fraud? All the things that we've seen, is that just belief in a court of law? It seems like there's massive evidence. What am I missing? You're missing them making an allegation and connecting it to fraud. And connecting it to an action. So what you're missing is when Rudy stands in front of the Pennsylvania legislature and says, oh, hey, by the way, you guys sent out 150,000 ballots, but 1.7 million ballots, but 2.5 million ballots came back. Like, and you counted them because you didn't verify the signatures because you can't, because the base signatures don't exist. Like, that would have been evidence of voter fraud. And I'm glad they brought that in the hearing. I just wish they would have put it in court. But like the Dominion stuff and the Georgia lawsuit for the Kraken, like Dominion cheated in elections in Venezuela in 2004. Even if they did, that doesn't mean they cheated here. Does it mean it's likely they cheated here? Sure. Do I believe they cheated here? Sure. But in court, you can't use a prior bad act as the basis of proof for a present bad act. Hell, even if they cheated here in 2004, you wouldn't be able to use it to say they cheated now. It's just the court rules. It's not me. I'm not telling you my opinions when I'm giving you the legal stuff. I'm telling you the court rules. I'm telling you how the courts are ruling. A lot of people conflate this for like what I want or what I believe or what I think is right. I rarely think what happens in court is right. It may be correct under the law, but is it right? No. No. Because, for example, a child enthusiast going free on a technicality isn't right, but it is what's proper under the rules, for example. So yeah. Anyway. Baron Wolfsbane says, I, Nick Ricada, hereby promise for my Cyber Monday special, I will cosplay as Tuxedo Mask the entire stream. I'm not wearing a damn tuxedo on stream. I'll die. Siren Jag says, hey, Rackets, as of 5 hours ago, hashtag Biden cheated was the #1 trending topic on Twitter. 4 hours ago, it was gone, departed, like Bill Clinton's fidelity, like the folds on the surface of Joe Biden's brain. I mean, gone. Yeah, Twitter is in the tank. Twitter has always been in the tank. They're fully in the tank now. They know what happens if Trump wins, by the way. Twitter may not survive a Trump victory. Kelly Sue DeChronic says, remember, Rainbow Brute launches on Sunday. Catch it on Comic Artist Pro Secrets and support Ethan Van Sciver. By the way, guys, unrelated, but the other day I asked for your help in supporting a Kickstarter. This one, Wizards and Relics. It funded. And I think largely because of us. So thank you. Thank you for that. Thank you for that. My son will be eternally joyful that the first project on Kickstarter that he gets to back and something that he had a little bit of hand in play testing and submitting ideas and stuff like that got funded and that he will get to get it. That makes him happy, which makes me happy. So, thank you. From the bottom of my dad heart, thank you. Okay. Let's finish this up. Luthien the Mortal says, I wonder how many people got shot over a PS5 today. Oh, that's the real doom pill. Funny Valentine. And over a PS5. Oh, how embarrassing. Funny Valentine 2020 says, Nick, worst anime you've ever watched and finished. Didn't I must have read that one already. How did that happen? Did I think that was a $5 one? I guess so. I said Tokyo Godfathers. I stand by that statement. Jake CB says, repeat of Rutherford B. Hayes versus Tilden for the win. What do we got? CJ says, oh, I thought you were talking a Boss Hog Pritzker. No. Pedro's Cigar says, will Flynn play a role in any of this? No. Flynn has nothing to do with this stuff. In fact, some guy was yelling at me about being wrong about Michael Flynn. Anyway, in the comments, it doesn't matter. Flynn is irrelevant to this. My proposition the other night, I still stand by. Flynn is an indication that Trump is not as confident in victory as he was. And so, if Trump... And this isn't a surprise, right? Like, Trump knows that as every day goes by, his chances of winning diminish. Doesn't mean he's not going to fight. It doesn't mean he shouldn't fight. There's nothing to be read into that other than the factual reality that as every day goes by, the chances of winning diminish. That's okay. It's not a doom pill or a black pill. That's just fact. Once it gets to the electoral vote, that's when it all happens. So, if Trump has less confidence in winning, he'll start pardoning people and tidying things up. That's all. And that's fine. That's okay. There's no bad thing in pardoning Flynn early. But you also don't need to pardon Flynn for the Trump strategy. And the idea that Flynn is taking away Sidney Powell's time to unleash the Kraken is ludicrous. For multiple reasons. But it just is. Let's see. Bad Vibe says in Drexel's voice, the things I do for these damn kids. And Mike Masiro says, hey, Rackets, can we shill the GoFundMe for my friend again? Thus far, I'm still the only donation. I'll DM you on Twitter the link. Here's the link. I'll put it up in the chat. Here, guys. Here's the link in the chat to go check out. It is for a GoFundMe for a deceased child. Check it out. Make your, determine if it's something that you are up for donating to, and then do it. If you are. I don't know anything about it, so that's it. Trump should pardon Snowden next. Trump should pardon Snowden last year, but I agree with you. Bitter Brian says, Tampa will be my first road rage. I can't wait to meet everyone in real life. Oh, buddy, bring your liver. You're going to need it. Bring your liver. You're going to need it. RoboNext666 says, Skynet hacked the election. Jillian Seed says, this was always a play for the state legislatures. It only is a play for the state legislatures if they weren't winning in court. If they were winning in court, it would have always been a play for winning in court. It's just how it goes. Mikhail Johansson says, Rhino equals ring muscle is now open. Gross. And then that's it. No, wait. Sabin Knight says, what a lot of chatters seem to not understand, you're relaying the election cases, simply laying out what Trump has to compare, and the odds are against him winning. Don't shoot the messenger. See you in Tampa. Hopefully I won't be too inebriated to carry on a conversation. Hopefully you are, because that means you're having a good time. No one important says, hashtag all $2 super chat matters. All right, guys. There is the show for tonight. What are we watching on Amazon? Let's find Amazon.com. Prime Video. My stuff. No, wait. Categories. Included with Prime. God, there's a bunch of really great, terrible looking movies. What time? It's 2? We can do 2 movies tonight? God, I don't know if I want to figure this out right now. I know what the second movie is. I got to figure out what the first movie is. Why don't we just go over to Twitch and find out? Let's go over to Twitch and find out, because I just don't know what it's going to be right now. Oh, yeah, Cocaine Wars sounded good. Angry Baneling says, when is the next Drex stream? Bring back Drexel. Drexel texted me today and said he would see me next week. So I assume this coming week. I don't know. The Bearded Dog, twitch.tv/Ricada Law. It is in the description of the video here. Go check it out. By the way, we're really close to 10,000 followers on Twitch. Come join up. Have a watch party. They're really fun. Come hang out with us over there. Let's play this outro. I'll see you guys on Twitch. I'll try and do something over the weekend for you. And we'll see what that is. Thanks for hanging out tonight, guys. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an art bag, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the wide shores of Nan to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the wide shores of Nan to the hills of Glenlivet, there's no one who explains the wrong better than Nick. So pour out